Um, Good morning, everybody. My name is Fatima Lahe. I'm the head of pro bono here at Bowman's. Um, my task this morning is a very nice one, but a very important one. It is really to welcome you all on behalf of Bowman's. Firstly, Charlene and the Women's Legal Center team, welcome. Thank you for the opportunity to host you today, and then to all our attendees for the day. Uh, Bowman's has a pro bono program. I head it up. We have a pro bono program across all our offices, both in South Africa and outside South Africa. Our model is a little bit different. Every lawyer within our firm is expected to do pro bono work. So we do a range of access to justice work, as well as we do public interest litigation. So coming to this particular matter, the matter is of interest to us, and hosting the symposium is important because we acted for the Human Rights Commission, who was asked by Justice Judge Desai to enter the matter. So we acted for the Human Rights Commission, and what we did then was to draw a comparative with other jurisdictions. That's basically a lot of the input that was very valuable input that we gave, and we ran with the matter on a pro bono basis, right from the Cape High Court, right up, right through to the Constitutional Court. So that is the extent of the interests of our interests in the matter. But then also on a more personal note, I am Muslim myself. So while this has never not directly affected me, but it was of importance. I mean, this for those of you that have to give you some context, I worked at Legal Aid South Africa in the impact litigation unit, and that time there was a lady that came. Well, we were hoping to fund the matter. She was from KZN, but that matter, like a lot of the matters that were brought by Muslim women, she didn't go through it. The matter got settled. Then and I had always had close contact with Women's Legal Center, with Huda in particular at the time, and they took the matter directly, you will recall, to the CC for the recognition of the Muslim marriages, and the Constitutional Court said you need to go back to the High Court. So, that is, and I have had an interest, and I had tracked the matter right through, but this was a difficult matter to litigate in many respects because, it's a question for a lot of women, particularly Muslim women, that from what I found, they didn't want to rock the boat too much. And if they did take the matter, inevitably they decided to settle. So eventually, as I understood from Women's Legal Center, they became the main applicant and then, brought the application on behalf of women, which then guaranteed that the matter would go to, to where it needed to be ventilated in the Constitutional Court, and that is exactly what happened. So it's a long history. It's, I think, a lot of heartache for a lot of women and children. Somebody that I had contact with, her mother was in her late 80s. And when this judgment came out, she said to me, she went to her mother, who's now very aged, and she said it was a very emotional moment because her father had abandoned them. And they all became professionals very high up in their own right. But the mother worked as a caregiver in an old age home. She's obviously very old herself now. So there was a lot of emotion attached to this. And I think it was also very painful for a lot of people, that their marriages are not recognized, and who are the children at the end, what you're not recognized, not your father. So yes, there has been peaceful recognition. At the time when I worked at Legal Aid South Africa, we also, you will remember the matter of Fatima Hassam, where there was a polygamous union, and Mrs. Hassam herself, she was, we was an attorney, and I just forget his name, but he was from Cape Town. We funded that matter at the Impact Litigation Unit, and whilst the court in that matter very cleverly, we had a very clever advocate, and he said, this is not a matter of whether you recognize polygamy, but what you're recognizing is equality. You know, on the basis of equality, you should recognize the marriage, you should recognize this Mrs. Hessam, who was a first wife, as as one of the wives when the husband had died. And that matter too, Mrs. Hessam was very old. And it was also a very sad matter because ultimately she had to share this flat with with the second wife, and she didn't have the funds to buy her out, and it is what it is. So kind of a swings and roundabout, not always easy, not, comes with its own territory. But, and I think this symposium for those people that are also online, and I hope that we have a good audience online. I just hope that today's symposium will go, just to the next step of tackling those issues that have come out from this judgment, and those issues, as I've understood, that are still kind of the sticky bits as to how one manages the clients who have these issues. So with that, I just want to say once again, on behalf of Bowman's, welcome to all of you. And also that I just hope that today will yield the results that we are here for. So thank you very much. Lean?
Now, Kinsani did this on purpose. She didn't tell me. Okay, let me just try. It's good. Good morning to people who don't know who I am or I have not said hello to this morning. My name is Charlene May. I am the director of the Women's Legal Center. I have been very honored to have this position since around about April this year. And before that, I was the head of programs for the center. And before that, I joined the center in 2017, just as the case was really being heard. And this has been, I think, the Women's Legal Center versus the President's case, people may know, was launched in 2014. So by the time I came around in 2017, when it was finally really being heard by the High Court, some time had passed. But I think that I was very fortunate to inherit the matter and to be able to steer it forward until we got the judgment in the Constitutional Court, and then to be able to do some of the post-judgment implementation around it, until Kinsani's come along and saved me. Um, so that's just an introduction, I think, to who I am and kind of where my knowledge lies in this. For us, it was important to have this symposium and this gathering of legal practitioners, kind of community-based paralegals, people within communities come to ask for legal advice, because we thought that it was some time since the judgment's been handed down. And of course, this thing happens with strategic litigation, right? Where we get, it takes us years to plot and plan a case. And then it takes us years to take the case from a high court all the way through to a constitutional court. And then by the time we get the judgment, we're so over it that we never want to talk about it again. But that's really when the important work starts. Because the important work is about what Fatima illustrated so beautifully earlier on, that it's about the women, right? It's about people's lived realities and experiences of this wonderful judgment that you just had. And so it is about then picking up the pieces of being exhausted by the matter, and then doing the necessary analysis, and then going full circle back into communities. And this is one of those cases where, despite the fact that we had the judgment, we continue to get so many questions around it from legal practitioners, from community-based paralegals, and from women within the community to ask around what the judgment actually means or what the advice is that they should be giving to people. And so the symposium allows us a little bit to go full circle and to bring it back to practitioners. It's also a little bit selfish on our part. So let us declare upfront that because we're a strategic litigation law firm, right, or law clinic, we can't take on every case that comes through the door. We provide services to women free of charge, and so we are wholly dependent on donor funding in order for us to operate and function. We're therefore not in a position to take on the 5, 6 matters that's driven by questions around recognition of Muslim marriages. Sheila can't take all of those matters on every week for us to litigate. We simply don't have the resources and we don't have the capacity. So part of today is really also to try and spark interest around practitioners so that we can create a referral and support network, so that matters can actually be referred out and women can actually get legal representation once they get. Access to justice remains a major hurdle and a major barrier to ordinary South Africans. And honestly, it is just going to get worse. Right? And so it really, this is one of those areas that it really does allow people an opportunity to see what it is that they can do to bring justice a little bit closer to ordinary people. So that's kind of our aim and what drives us. I think the other issue is also that we're humble enough to recognize that even though we've achieved this wonderful judgment, that it's not going to be the perfect solution for everybody. And what's important for us when we talk about access to justice and we talk about equality, that we talk about substantive equality and we talk about really shifting lived realities. And so we're very interested in hearing about the challenges that practitioners are having and challenges that women are having in terms of accessing courts, to realize the rights that the Constitutional Court has given to them. So today is going to be a bit of a journey. I'm going to tell a bit of a story to set us off. And then we're effectively going to go on a little bit of a journey around the history of the case, where we find ourselves now in the process, and then I guess the role that all of you can play or the input that you can give into it, to take the matter forward. I want to flag right at the beginning that the Women's Legal Center is not a feminist Islamic law center or law clinic, right? Our expertise lies in the Constitution and around advancing constitutional rights for women. That's what drives us. And this case and this issue sits at the nexus of religion and constitutional rights. But we're not the religious experts. We have some fabulous people that are fabulous women that's going to come and talk later on, and as the day goes on, around that intersection, and around where the religion intersects and sits within this. I should also caution that we are the Women's Legal Center. So for people in the room and for people joining online, it is going to be an unapologetically display of women and women's rights. So if you were joining to figure out how to advise your male client, we're not going to give you advice on that. That's not where we're going today. So I just wanted to make that very clear. I'm sure that there always is a little bit of criticism afterwards that it was so gender focused or it was so women's rights focused that it wasn't for everybody. We are not for everybody. We're okay with it. So we're just putting that kind of front and center so that you are aware of it. Yeah. And so let me also just say thank you at this stage, for Bowman's being so generous in making the space available to us. We're going to miss Bongumusa Sabia, who is from Bowman's Johannesburg office. And one of the things that I experienced when we talk about collaboration and partnership is that we can't do things by ourselves, right? I think it's one of those things that feminists will identify with, is the idea of sisterhood and partnership and solidarity. And it's something that the center really relies on to be able to do its work. And so the guest speakers that we're going to have later on today, we've been keeping Aisha quite busy over the last while with this campaign. We've got Fatima Sidat and Fatima Isop and all of the women that really have played a role for us to get to the point where we have this judgment, and the women that are still playing their part behind the scenes in terms of the legal advocacy or law reform advocacy that's taking place, that we'll also talk about a little bit today. So it really does take a sisterhood, and it does require partners. And I think that Bowman's has been one of those partners that have always made themselves available to the Women's Legal Center to be able to do the work that we do, especially when we get to our litigation and especially when we need correspondence for the Constitutional Court. So thank you very much for that. And then thank you, as I said, to people that have taken time out of their busy schedules today to join us because they have an interest in the topic. I hope you leave here a little bit more enriched and having learned a little bit more than you did before you came into the room. Story time. How did we get here? And so Fatima talked a little bit about some of the earlier cases, and Kinsani will go into, I think, a lot more detail around them as we move forward or as we go on. But I think one of the important things to probably just say is that when WLC opened its doors in 1998, 99, this issue was one of the first issues that presented itself to the doors of the center, right? And it was one of those things or one of those issues that simply would not go away, right? Sometimes things present, and I mean, I think as lawyers, we know this. Sometimes things present and they're able to resolve themselves or sort themselves out, whether it's through settlement or whether it is through somebody else taking the case off your hands and pursuing it and doing it much better than you ever could, right? But this was one of those things that it would not leave us. And because it would not leave us, it became one of the things that continued to drive the work that the center was doing. And that was largely because women continued to come and knock on the door to say, we need help in resolving this issue. And whether it was issues around maintenance or whether it was divorces, whether it was the distribution of property and assets at the termination of the relationship through death or through divorce, it was something that would continuously come up. And so one of the things that was, from a strategy perspective as lawyers, we're faced with how do we deal with this? And one of the early kind of methods or strategies that was employed was, let's do this piecemeal approach to litigation. We know the big issue. The big issue is the non-recognition of the marriage, right? But in order for us to get there, we need to build. Right? And so there's going to be some of the earlier cases that Kinsani will talk about later on. But we also wouldn't be here today if it wasn't for those brave women that were prepared to see the road clear, right? The 5 years, the 6 years, the 8 years that it takes to litigate a matter to completion. And so this piecemeal litigation really allowed us to explore and to unpack what the issues were, where the resistance sat, and for us to start developing what the arguments needed to be that we would be able to put before court in order to get a resolution around the recognition. It also helped us from an advocacy perspective, because if you build up sufficient litigation and you have sufficient judgments, you now have something that you can point at when you do advocacy and engagement with government, because you can start saying to government that the High Court has said this, the Supreme Court of Appeals has already recognized this issue. You might as well codify it and put it in a law. And so that's the tools really, or the methodology that we used at the time in order to advance the issue around the recognition. For us, the law reform aspect, I think, was always important. So while we were litigating, there was also this engagement with the South African Law Reform Commission around the investigations that they were doing. It was the early years of democracy. So we were looking at, from a family law perspective, where are all of the families that were excluded or not recognized within the legal framework. So we see the development of African customary law, and we see the development of legislation around that in the form of the Recognition of Customary Marriages Act, for instance, that comes through. We see the development around maintenance and new maintenance legislation. There's new legislation around domestic violence. There's white papers around the family. We won't talk about that because that continues to be slightly problematic about what makes up a family. But this is the road around law reform that took place during the early years. And so the recognition of Muslim marriages in the form of a much bigger Muslim personal law project was actually engaged with by government through the South African Law Reform Commission. And we see different discussion papers, issue papers coming out over the years, but we see what we view as a lack of political will to pass legislation. Right? And so even though there's recognition is being given to other forms of marriages and other forms of relationships, we're not seeing the same development in the recognition of Muslim marriages. And I think that could be for various reasons. And some of what was cited by the state is that there wasn't agreement within the Islamic community or the Muslim community themselves around how they wanted to regulate it, right? But at the same time, we could say, but that's not really a valid argument, because you didn't come to all of us and say we must all agree on one law or one policy around any other particular law. So why are you being disingenuous by trying to force us to agree to this issue? We could also just say that the state really struggles with this idea of religion and how to regulate religion, not just Muslim religion or Islamic religion, but they also struggle to regulate issues around Christianity and any other form of it's very tiptoey. And we could argue that, well, that's because the Constitution recognizes the right to religion and freedom of religion, and the state really, is respectful of that right. But I think based on the experience that we have, that provides a very nice hide behind, because it's very difficult, and it's maybe too difficult for them to want to engage with. And so what we are experiencing, I think, between this period of 1999, when the center starts doing this work, to 2014, is this continued implementation of piecemeal litigation and getting very progressive and very good judgments, but not actually getting to recognition. We keep on stopping just short, right? Until we have Owen Rogers, who's now at the Constitutional Court, and he was acting judge at the High Court at the time. He hands down the judgment in 2014 in a matter that was joined to the WLC versus the president. And he kind of gets to the crux of it in an interim judgment and says, but why are you not just recognizing the marriage? Why is there not just law reform? Recognize the marriage, people will stop coming. right? Very pragmatic approach to it. But this then leads to WLC launching in 2014, the WLC versus the president case. And what we really wanted to show was that the state had an obligation to legislate, to pass actual legislation. Right? It wasn't enough that courts were handing down judgments, forcing women to come back to court and saying, oh, but in S versus S and in T versus T, and this is the precedent based on the jurisprudence. But what we said was that we needed clarity, and clarity can be found in the pages of statutes. And that by not doing it in that way, that was discriminatory, right? Because you're recognizing other forms of marriage in legislation or through legislation. And by not recognizing it through legislation, so that's discriminatory, and by not recognizing it through the legislation, it was actually a form of gender discrimination, because it was women that were bearing the brunt and carrying the weight of the non-recognition. It was women that are being forced to come to the WLCs and to go to lawyers and hand out money and spend time and resources in order to get access to courts. Only then to get to courts, and courts, because there's non-recognition, you could only benefit within the advances that have already been made. So by then it was issues around inheritance, it was issues around maintenance. But the division of this estate, right, the assets and the property that was accumulated at the termination because of a divorce, that still hung in the air very heavily, right? And it was women that were being asked to come to court and to try and litigate or force an equal distribution or a just and equitable distribution of the assets. And that we said was discriminatory, this burden that women must carry in the scenario. And then we said, well, if you are with us on the obligation that the state has to realize rights in the Constitution, and if you're with us and you agree with us that there is that there's discrimination, then you must be with us that there's been a failure on the part of the state. And if there's a failure on the part of the state, then you have the obligation to fix it, or to order the state to fix it, right? So that's how you get over the hurdle around the separation of powers, right? And this is what we go to court for in the Western Cape High Court. And we get a very good judgment in the Western Cape High Court, a judgment that can then take us all the way through. But of course, strategic litigation and the rights are never that easy. And so the state appeals. The president appeals with the Minister of Justice. And the president's appeal is largely premised on the idea that I did not fail because I just got here. Right? New president. I don't know what my predecessors did. I just got here. I found out this is a thing. And I'm taking exception to the fact that there's a judgment that says I failed in my obligations. And that's really the crux of the issue, right? And so off we go to the SCA. And this is what we're saying. Well, the High Court was right. We need the legislation. And the SCA was a strange experience because the council more or less for the state conceded that they had the obligation and that they are working on it and that we're just premature. We're just being in a hurry to try and get this thing done. And if we give them time and we give them space, then they will get there, right? And so the Supreme Court of Appeal basically then comes and says, there's discrimination. You've acknowledged that there's discrimination. You must fix it. You must pass law to recognize and deal with this issue. We were really helped and supported on on this journey from the High Court through to the Supreme Court of Appeals and to the Constitutional Court by some key role players. And I'm going to flag some of it. In the Western Cape High Court, there were a lot of people. Not everybody were cheerleading for us. So I'm not necessarily going to talk about them. I'm going to talk about the people that supported and really helped us to get the judgment. So we had the United Ulama Council of South Africa that was joined by the Muslim Judicial Council that came and supported the case from the Western Cape High Court all the way through to the Constitutional Court. And what they were really saying was that they recognize that because there's not legislation, that women are having their rights trampled on, and that Muslim people live in a constitutional democracy, and that they therefore need to make sure that they are complying with the Constitution and the rights in the Constitution. And they would be in favor of a court granting an order that would compel the state to legislate Muslim marriages. They would engage on the content of what that would look like through the parliamentary process. Okay? So yay for us. We had the Muslim Assembly coming and saying, women come to our organization on the daily to try and get advice on what to do. Things are out of hand because they can't rely on the existing structures to give orders that could be enforceable in court, right? A woman can go to a religious structure or to her religious leader and obtain a divorce order, or can go and obtain an order that says this is how you're going to divide the property. But she can't take that to the sheriff or to the deeds office to transfer the property. So whatever decision is being handed out requires goodwill, good faith on the part of both parties in order to execute it. And legally, there was nothing that would bind or compel action. And so they were coming to say, we need you to help court. We need legislation and a law in order for us to get to the point where these women wouldn't need to come to us anymore because they would have legal certainty. We also relied quite heavily on the Commission for Gender Equality that came in the High Court all the way through again to the Constitutional Court, because they very strongly came on this issue around the state having an obligation in the Constitution to enact legislation, and that there was a failure on the state to have done that, and that they tried some time back to assist the state because they also drafted a Recognition of Marriages Act at the time that they were desperately trying to advocate and get the state to adopt and to use and take through the parliamentary process. And then we had the South African Human Rights Commission, and they came to really also talk about what is the state's international obligations and duties, and how the state has failed in meeting those international human rights standards by not recognizing Muslim marriages. And all of these things really helped from a public interest litigation perspective. All of the different building blocks really helped us to be able to articulate our case when it came to it finally at the Constitutional Court. And so I think part of what makes it a story to tell is it makes it a little bit easier for all of these legal arguments to fit into each other, right? In terms of showing that there's an obligation in the Constitution to enact the legislation, that because you haven't done that, there's discrimination. And that discrimination isn't just on paper, it's not just about formal equality, it's also about substantive equality, because again, you have this burden that women are carrying. And we're showing that because we have these other two cases that by then had been joined to the matter, which were women that were also trying to, in the one instance, it was an inheritance case where after her husband had passed away, the son-in-law managed to obtain a divorce and could then argue that the spouse was not entitled to inherit anything. Then the other matter, it was a divorce matter where the wife wanted access to her husband's pension because he was close to retirement. And so these cases could illustrate to the court the lived experiences of women and how they were actually struggling under this non-recognition banner or umbrella. And then to be able to say, well, there's a failure. And if there's a failure, then you have an obligation, court, to intervene and to step into the fold. The story is a very nice story, but things don't always work out the way you planned brilliantly in 2014. And so if you've read the Constitutional Court judgment, you would realize that a lot of the arguments that we maybe had put forward in the High Court never actually made its way through to the Constitutional Court or the Constitutional Court judgment. I think by the time it got to the Constitutional Court, the court was like, what are you here for? All of this is so obvious that we actually don't need to even dig very deep, right? A case has been made out for the discrimination. The state can't defend it. So if you can't defend the discrimination and you can't justify it, then you have to deal with it and you have to address it, and you need to address it through legislation. And so the stories around the failure and that there was this broader obligation and all of these things, the flowery language fell away. It's still a wonderful judgment. I just happen to be a kind of bit of a judgment nerd. So I like long paragraphs with poetic language around what rights really mean and flowery things. And we're not necessarily getting that from the Constitutional Court, but maybe that's another symposium where we can unpack what happened to the flowery language of the Constitutional Court. And so what we do have is a judgment that is actually very concise and precise in the way that it sets out what the state has to do in order to fix this. And I think that therein lies the strength. So the order itself is the most important part of the judgment in many ways. We have that somewhere. Kinsani, is that my holding slide? Well, Kinsani gets the holding slide. And before I move over to the judgment or the order or what that means, does anybody have any questions or input or just wants to say something? Yes. I do not. Do you need the mic? I'm being forced to use a mic, then you shall be too. Okay.
Thank you. Thanks, Charlene. Yeah, while you're getting set up, I just wanted to find out from you specifically in hindsight, the piecemeal approach versus the more consolidated law reform, approach. Would you have done things differently back then?
I think we didn't really have a choice. And Fatima hinted at it earlier on. So we tried going directly, very bravely, direct access to the Constitutional Court and said, recognize Muslim marriages. And here it is, and we're bringing this whole big case because this is the Constitutional Court of flowery language and very brand new, and we're busy getting all of these wonderful new rights, and they're giving normative content to all of the rights in the Constitution, and the Constitutional Court said, no, go back. So we didn't have a choice. Effectively, by having gone straight up, the court was saying, no, go back down. Go start at the High Court. Go and figure out what all of the issues are. Go and unpack what it is that you want us to do. Get all of the parties involved. And then come to us. Because coming to us like this without having all of the legal arguments and all of the rights ventilated is not going to be helpful, and we're not going to be able to help you to do it. We can have a whole nother symposium around that. But besides creating jurisprudence about when direct to come and do direct access, which is an achievement on its own, the lesson that we learned was that sometimes it is best to, even for us as lawyers, to take a slower route in terms of looking at the different aspects of the issue. And so by the time we get back to the Concord and ask them to look at this issue again, we're able to show them all of the ways in which over the last 20 years, they have, and the lower courts have actually tried to unpack and have, in certain instances, given rights to women. So we were able to say, well, the SCA recognized this, and you as the Constitutional Court, you recognize the right to inheritance. You recognize the right in polygamous marriages, for wives to inherit. So we're coming to you because we're saying, we're all tired now, right? And you asked us to engage in the process. We've engaged with the process. We've got proof of how we've engaged. And so data matters, right? The numbers, the statistics, the stories of women, all of these things in litigation, actually, and especially I think in strategic litigation, it does matter because it allows a court to find itself in the shoes of the person that's experiencing the oppression or that's experiencing the discrimination. And I think it can only help to elevate the matter. It was a long time. It took a lot of money. It took a lot of resources. But I don't think that necessarily, or that should be parked at the door of the court, right? I think it feeds directly back to how we see law reform happening within the country and the slow progression of that around policy and around laws finally being adopted. And then we sit with the struggle of implementation. And so it is all part of, I think, that bigger issue around how do we unblock the state when it comes to the development of law, because we know they can do it really quickly if there's political will to do it. And if there isn't, then 20 years, 30 years later, you know, I'm standing here and I'm saying they are still busy. Anybody else before we just jump into judgment? Yes. Yeah.
Hi, Charlene. Thank you so much for setting out the history so clearly the way you did. I think what I want to get better clarity about is that considering that we don't have legislation at the moment, right? So it would be correct to say that there's partial recognition at this particular juncture. And if that's the case, practically what do we do with this partial recognition? Or am I incorrect in saying that it's a partial recognition and we should just see it as the courts have now recognized? We're just seeking that we have legislation that's going to regulate Muslim marriages. Thank you.
So Kinsani later on, and I think some of the other speakers will unpack exactly what it is that's on the table right now. But let me take you through what the court ordered. And then I'll just give you a little, as I go through it, give you an update on where we are with what. What's on the screen is a snapshot or a summary of a much longer page that I don't have, unfortunately. I think it's in my bag. I'm so sorry. No. It's But why, while people find things for me, Kinsani also gave me a list of questions, so I just want to double check that I've gone through them, I've covered them. Kinsani had a question that said, I should talk to people about the challenges that were faced in sustaining litigation over such a long period of time. And I think the obvious thing is money and resources, right? It's human resources. I stand here because I had a Huda that came before me, and Huda was able to, thank you so much. And Huda was able to do what she was able to do because there was a lawyer before her. So the issue definitely didn't get to the Constitutional Court just by one person being brilliant at it and being able to steer it through. So I think that it is important when we look at kind of the cost, the price that was paid to get us to this point, was it took financial resources, it took long hours, it took many lawyers that worked on it and advocates that's worked on it over the years. And then it's taken really like brave women to come forward. Because as Fatima says, you know, the pressure on women to come and stand up and be able to face kind of patriarchy within their community, especially within a religious community, is heavy. It's a heavy burden to carry. And so it's important, I think, to acknowledge that, especially when it comes to piecemeal litigation, that we acknowledge and that we recognize that we need ordinary women to be able to do this work. And that because we know that it is going to be a 5, 6, 8-year journey until it's done, that's a lot to ask of somebody, right? To have not just their name attached to it, but to be able to say, well, you're going to have to wait till the Constitutional Court in order for you to get a decision out of this. And so one of the parties, for instance, that was in the case that was joined to us, had to wait until the Constitutional Court for a decision around the recognition of her marriage in order for her to then come back to the High Court to be able to deal with her divorce, right? And whether or not she then had to come and argue that she had a right to half of her husband's pension. So I think that that's kind of the challenge that we don't often think about, or that we don't often talk about, and that we can start off the journey and be all fully invested, and that we have a client that 2 years in says, I'm done. And that we have to make peace with that. Yeah, so I think that that's one of the big things. Kinsani had a question around the judgment shifting the balance between religious freedom and gender equality. And I think that one of the things that the judgment actually doesn't really touch on, because the court, I think, recognized that it wasn't for them to engage in a religious debate around what the content of the religion was, that needed to happen through law reform. And that was a policy decision that needs to be taken by the state as to what extent they want to incorporate religious aspects, practices, traditions, to what extent they want to incorporate those into a legislative framework that then recognizes the marriage. Yeah. Let's talk about the judgment or the order. So, as I said, we got to the Constitutional Court from the Supreme Court of Appeal, the state appealing and us cross-appealing, and really just trying desperately to get everything into and as much information in front of the court as we possibly could. But what the Constitutional Court does is that it effectively certifies the declaration of invalidity that the Supreme Court of Appeal had handed down. So the Supreme Court of Appeal then says, well, if we have existing statutes that recognizes other forms of marriage, right? We've got the Marriages Act that regulates marriages in the country. And if we have this legislation that recognizes the marriage, and if we have a Divorce Act that deals with the dissolution of the marriage after an irretrievable breakdown, but these two pieces of law are excluding this category of women, then the problem lies with those two pieces of legislation. And so we're declaring those two pieces of legislation invalid in as far as it doesn't recognize these people, right? Because we're trying to treat everybody in a substantively equal manner. The starting point is, let's get to formal equality, right? So let's get to the law and the paper. Let's just make sure that on paper we're treating everybody the same. So we're then saying that these statutes, in as far as they don't recognize the marriage, in as far as they don't deal with the dissolution of the marriage, and in as far as they don't deal with what must happen with the assets of the union at dissolution, that's unconstitutional, and that they really do need to address that, and that needs to be remedied. It then also gives us that the common law definition of marriage is declared to be inconsistent with the Constitution and invalid to the extent that it excludes Muslim marriages, right? And so even though the common law definition doesn't talk about religion, it doesn't talk about a Christian marriage and a blah, blah, blah marriage, but the legislation itself flows from that common law, right? And who we recognize. It then suspends the declaration of invalidity, right? So it then basically says, well, for the next 24 months, we're going to give the state the opportunity to remedy the defects within the Marriages Act and within the Divorce Act. We'll give them the 24 months from the date of this judgment to fix it, right? And we're not telling them how, because we're allowing them to do it. That's their constitutional obligation. It then does something wonderful. It then puts into place an interim structure that allows women to get divorced under the Divorce Act. It allowed for women to approach a divorce court and get a divorce order pending the state enacting this legislation that's going to recognize the marriage, or that is going to amend the Marriages Act, or that's going to amend the Divorce Act. So in the meantime, there's something in place that women can come to a divorce court for, and they can get divorced in terms of the Divorce Act. There were some confusing dates there, but this is probably not as important anymore because we now have the amendment to the legislation. So we'll come back to that section of the Divorce Act that was in fact amended. And we'll deal with it in a little bit more detail, talk about the bill and talk about the act and what it does now. It then also says that it then also deals with polygamous marriages, right? And it says that pending the coming into force of legislation, right, the Recognition of Customary Marriages Act will apply to Muslim marriages where those Muslim marriages are polygamous in nature. Right? And this is something that we had asked for way back in 2014 in the High Court, is we can't be having conversations around polygamy and around how polygamy is contrary to the public morals or the morals of society when you've enacted legislation in the form of the Recognition of Customary Marriages Act in which you recognize polygamy. So when you talk about how it's so difficult to regulate polygamous marriages, As the state, you're actually just being disingenuous again because you managed to do it as far back as 1998. So what's happening? So this is some of the examples, I think, of just how we were able to extend. And one of the things that was asked for was that the Department of Home Affairs and the Department of Justice needed to publish a summary of the order in newspapers, radio stations, without delay in order to make sure that ordinary women were aware that the decision was handed down. And that was done. The order itself gave us quite a bit to work with in terms of trying to make sure that women were aware that they could go to divorce courts, right, and apply for divorces. The difficulty that I know that Sheila, who's one of our legal advisors, experienced is that the courts were not ready. When I'm talking about courts now, I'm talking about the lower courts were not ready. So the regional magistrates courts that also deal with divorces, they were not ready for this order. They were not ready to deal with this issue at all. In terms of being able to assist women with filling in the necessary forms. One, they didn't know the judgment existed. So whereas the state advertised in all of the newspapers to tell all the people, yeah, you've got rights, they didn't actually tell or develop standard operating procedures for the clerks of the court who didn't know what to do with it. I think up until early this year, there was still no standard operating procedures. And so they kind of still don't know what to do. So when we talk about full circle and how orders work, this is some of the challenges. The good news, and something, as I said, that Kinsani will unpack a little bit later on, is that the Department of Justice immediately got onto things in terms of the amendment. It's as if they met with the Department of Home Affairs. The Department of Home Affairs said, well, yes, we've seen the order. We're now going to go into a policy development process. And the policy development process is going to require us to do public consultations. And what we're thinking of is we're thinking maybe we should have one big law with a chapter for each form of marriage. Or maybe we should just have one law that recognizes everybody. We're still not sure. So we're going to do a green paper, and then we're going to do a white paper, and then we're going to do a bill, right? And the Department of Justice was, no, we're going to amend the Divorce Act. And then we're going to leave you to get on with it. So it was a bit of an abandonment issue in that justice literally got onto it within 18 months and amended the Divorce Act to allow for women, Muslim women, to now approach the court for divorces. So that when we come back to your question around, it feels a bit like we have piecemeal recognition, right? In the sense that we have recognition around the deceased estates because there's court judgments and there's some amendments to the legislation, the Interstate and the Testate Succession Act. So that allows women to come forward and to have rights. We have the amendment to the Divorce Act that now recognizes the Muslim marriage for the purposes of the divorce. It's a bit late to recognize it. Wouldn't want to say pointless because it's important for the purposes of getting the divorce. But when we talk about the human side of it that Fatima was talking about right at the beginning, for the human side of it, it's still really depressing that the only time that the state will recognize your Muslim marriage is when your husband is dead or when you're getting divorced. The rest of the time, you're kind of walking around without any proof whatsoever. And you're having to explain this to people. So That's the status where we find ourselves now in terms of the order that was granted. The law reform process is underway. You'll remember I said the state had 24 months in which to pass the legislation. The 24 months expired in June. It was June of last year. June of last year. And they went to court and said it was elections, and there's a new minister, and there's a new president, and, oh no, it's the same president. But it was like it was a new president. New minister, new department, new everything. And so we've introduced a bill, which they did in in December of 2023, they introduced the bill into Parliament. And so, of course, the term for that Parliament lapsed prior to the elections. So the bill that was before Parliament lapsed just after everybody sent in their written submission. So there was a public participation process. So that lapsed. And then when Parliament was started up again, the same bill was reintroduced. And if you're a law reform nerd, there's a very nice minute of that meeting on PMG where the portfolio committee members all say, woo! You can literally like censor it when you read the minute. It's like, woo, we just got here. No, take it away. This is our first term. This is our first 3 months. We're not looking at this thing. Hide it somewhere from us. We don't want to know about it. And that's kind of what happened. They declare at the end of the minute that they know too little about the subject. This is marriage law in the country. They know too little about the subject. And so they're not going to engage in it now. They want the Department of Home Affairs to go and do further consultations, look at everything again, prepare a proper briefing, and then they will look at it. They did start late last year, again, a round of public participation. It's probably a good thing. They did community-based public participation. We don't always see that with all forms of legislation. So they literally went into communities and hosted various engagements at community level with the draft bill. We've been advocating for a long time for us to get rid of child marriage in the country. Warning, I'm veering off topic. But we've been advocating to, against child marriage, to increase the marriage age in the country to 18 without exception. The public participation processes come through, and people think people should only be allowed to get married from 23 and up. So that for me has been a very interesting development. They also think people should go for counseling before they can get married, mandatory and obligatory counseling. I don't know who's paying for all of this, but it's been an interesting experience, and I think that it has allowed Parliament to really engage with the issues. But more importantly, I think it's allowed ordinary South Africans who've shown up at these community halls to actually engage with it. They have now reached out, the department, the Portfolio Committee on Home Affairs has now reached out this week to say they're getting around to talking to civil society structures and with the religious sector. So I'm a bit disappointed that they've waited to deal with the religious sector right at the end. And hopefully that isn't a major red flag being waved. We know that we're heading into municipal elections next year. And that members of parliament will go and do their electioneering within their constituencies. So hopefully that doesn't delay it. They have until June of 2026. So the Constitutional Court gave them an extension. So they have an extension until June 2026 to pass what is going to be the Marriages Act, because at a policy level, they've taken the decision not to have a separate Muslim Marriages Act. It's going to be one piece of legislation that they are calling an omnibus legislation. And other people are just saying it's a single marriage statute, which is what the Law Reform Commission recommended like 5-6 years ago. But Home Affairs wanted to start over, so it's okay. So we have a single marriage statute that is going to look at recognizing all of it. And in part, we find ourselves here where we're going to recognize all forms of marriages in the country because of this judgment. And because Muslim women, I think, were brave enough to stand up. So it spills over into all of the other areas because we're now reviewing aspects of all other forms of marriages in order to recognize them. We're not necessarily happy with the bill, the content of the bill. It's all still problematic, but it's a work in progress. But that's where we are in terms of the implementation of the Act. Questions, engagements? Spoke way too fast and we didn't follow you. Huh? Nothing online. I don't know, are online people able to ask questions? Oh, okay. No? Fabulous. I was so clear. Yay for me. Thank you. Kinsani, what are we doing next? I'm early. Did I finish early?
Yes, you did. So we were supposed to break at 11. So maybe I can just ask if we can just take 5 to see if we can play just a short clip.
Yes, we can do that. So we'll take a 5-minute break
Yeah,
and
just
then
5
play the
minutes.
clip?
Yeah, yeah.
Okay,
just
we'll
while
take a
we
5-minute break
yeah.
and play the clip. The bathrooms are out the door, the person with no sense of direction, out the door to the right, straight through past reception, past the elevators, past reception, and then to the right. Thank you.
Holding fast. Oh, sorry. I'm sorry. Before you step away, I'm the owner of a black BMW, CLA 200. The number plate is CAA 2802. Can you please go park at a visitor's bay? Or is it you? Oh, yeah, you must park on the visitor's bay. So can you please move your car? Okay, thank you, everyone. Are you gonna, Brett? Are you gonna play it from there, or should I? Okay. So we're just going to play you a clip. This is a clip of one of our clients who we represent in a separate case. It's a housing matter, and we just felt that it was very important for us to show what women actually go through when there is no recognition.
Sumaya, at what age did you get married? And at the time, did you have any assets? And were you planning on furthering your studies?
Okay, I was 19. I just finished matric. I was 19 years old, and I met this guy that was, and I thought he was like everything that I wanted. A little bit older than me, so much in love. I had no assets at the time. All I wanted to do was, we were going to get married, and we were going to set up a family home, and we were going to live happily ever after.
Now that you were married at 19, what were your plans for the future with your husband?
At the time that we got married, we were, because of our circumstances, we were then living with our in-laws. And as a young couple, that's not what you want. So that's when I went and I applied for us to have our own house, and I went to and applied at the city of Cape Town.
What was the process of acquiring your first home?
Okay, when I found out that we could apply for a house at the city, the offices were in Hout Street at the time. And we spoke, but he was working away. I remember he was working in Bloemfontein at the time. And then we agreed that I would go, because I'm at home, and I would go and I would apply. And at the time I went and I applied, we could apply because we were then a married couple, and I used his ID number and his stuff. I put his name down, and that was fine. But in my mind, it was the two of us were applying to have a home, even though he was the breadwinner.
At what point did you actually realize that you were not a co-purchaser but a dependent in terms of the house agreement?
Okay, we had been living in the house that we got from the city for about 7 years already. And things weren't all that rosy anymore. And then he actually left. He walked out and abandoned us as a family. And everything seemed to have happened all at the same time. I received some notification from the city that we had to come forward. They wanted to see us in a meeting. When we got to the city, that's when all of this hit me, because then we had purchased the house for a certain amount, but there was a huge arrears because he had stopped paying. He just wasn't paying the way I thought he was paying.
Once you found out the house was in arrears, what did the city of Cape Town offer as alternatives?
Okay, what they offered was you had to pay a certain amount that they told you towards the arrears. I specifically remember that amount. It was an amount of 600 Rand. I was alone in that meeting. He didn't join us for the meeting. And I actually felt like I had no choice. I had all these children and I needed a home. Where were we going to stay? So I had just started working a little bit before, a few months before that. I was actually earning at the time, I'm not even shy to say, I was earning 1,000 Rand. I then had to go, but I had a good relationship with the guy that gave me a job. It was somebody that my sister knew and she worked at the same company. So I walked over the road, I asked to see him, and I told him, I'm coming back now at the city. I said, I'll be back now. I will sign this. Please give me a chance. I walked over the road. I spoke to my boss. He gave me the 600 Rand. That's the amount they said they needed. And then I went back over and I paid it to them. So I feel that what was I supposed to do if I didn't give them that money and sign that? I wouldn't have had a place to stay. I mean, they weren't going to let me stay there and not pay anything.
So what was your way forward after signing the acknowledgement of debt and paying the installment that the city requested?
Okay. After I had signed that acknowledgement of debt at the city, I think I just then went into survival mode. I just loved to work and to see to my children and to pay what I had now signed for because we needed a roof over our head. That's really how it was. It was tough. It wasn't easy. And I can honestly say, I never tell my children this, but if I didn't have them, I don't think I would have survived because, you know, when your husband abandons you and walks away from you, the community I live in the community, that's not one of the easiest communities to live in. They look at you, you know, people, this is the reality of the situation. People kind of like other people's distress. And because they now also see you as, oh, your husband walked away from you. You feel less of a woman already as it is. Mm-hmm. And they treat you like that. They don't want you to be around. They feel sorry for you and in front of you, shame. But behind you, they don't really want you to be a part of any of their groups because now, like, you know, that they're scared you're going after their husbands. And, you know, people, like I said, it's not an easy situation. You really feel alone. And again, if I didn't have my children, I would never have been able to have gotten through that period of my life. I eventually found the courage to go and find help to get out of this marriage. It took me 7 years to actually then get a fasakh. I went looking for help first. I went the legal way. I went Islamically. And, you know, when I went legally also to look for child support, I feel that I was really shamed there. It was something that I would never do again. And I never did again. I got along on my own after that. Islamically, it was like people didn't believe me. They didn't believe the things I was saying. You know, I felt always like I'm the problem. And then eventually, like I said, I gave up and I just totally threw myself into just looking after my family on my own and getting along on my own. And then there was somebody, then I eventually got to somebody in our area. And my children were then going to, you know, like for the Islamic studies there. And I think because this person got to see, he then knew us and then he got to actually see the struggles, you know, without me even having to say. And that was how I got the help to eventually, that led to my fasakh.
So stories like Ms. Beste's live reality is one of the main reasons why the Women's Legal Center actually launched the Women's Legal Center Trust versus the President of South Africa in December 2014. A lot of women like Sumaya Beste were being prejudiced, especially at the end of their marriage. The Women's Legal Center actually litigated a case in Goodwood where a husband wanted to evict his first wife and his children out of the house so that he could live with his second wife. So that's why it was very important to ask the court to make an order. So in terms of Islamic law, Muslim marriages in their nature are out of community of property. And due to this, the Constitutional Court in June 2022 ordered that women in Muslim marriages can approach any of the family courts to institute divorce proceedings. And in these divorce proceedings, women like Sumaya can request the court to make a just and equitable distribution of assets at the end of the marriage. This is just to ensure that all the women that were homemakers during the duration of the marriage, women that supported their husbands and took care of their children and did not work, are no longer in a more vulnerable position when the marriage ends.
Okay, so I will take a round of questions, and then we can take a break until 11:20. Any questions, any reflections? Okay.
Sorry, just on the video with Sumaya, I just wanted to know, like, okay, firstly, probably you might not know, when she applied for the house, when she was 19, after she had married her husband, was it because she had just trusted that just applying in his name would be okay, or was there something that was prohibiting her from also applying in her own name as well? And number two, at the moment, what happened to the property?
Okay, okay, let me just quickly answer. Let me stand there so that the online people can see us. Okay, so we are currently in the Equality Court to resolve the house issue. So what happened was that with the City of Cape Town housing scheme policy, you could only apply for the house if you were either a breadwinner, right? And at this point, Sumaya's husband was the breadwinner, but everybody else was then recognized as dependents, right? So in 2020, no, in 2022, the Western Cape Equality Court declared that the City of Cape Town housing scheme is unconstitutional because it discriminates against women. And it is from that case where we are currently litigating to get the house into Sumaya's actual name. So with the Abdullah order, the order said that women, the City of Cape Town should effect transfer in both the husband and the wife's name, right? But and only once you've paid up. So what had happened was that Sumaya paid off the house in 20 years, and as soon as she paid off the house, she needed to she requested for transfer. She then said, no, I can't because this house is gonna go into his name. I don't want it to go in both his name and my name. I want the house in my name because I'm the one that actually was making she's the one that made the arrangements and the one that was actually paying every month to ensure that she secures the house for her and her children. So what then happened was that Mr. Bassett then came back now recently demanding that it's his house because everything else till today still comes out in his name. So we are currently in the Western Cape High Court Equality Court to resolve this issue. And Professor Sidat, who's actually here, gave us an expert affidavit to actually unpack the dynamics of Islamic law in order for us to show the actual discrimination. So she'll maybe touch on it just a little bit, but in terms of like Islamic law, if you are married, you are then legally liable for your wife and your children. So it's not a 50-50 split. You as the breadwinner, you are liable. So we are using that context to tell the court that he should forfeit his share because he's actually indebted to her, right? And I think also it's very important why she mentioned that it took her 7 years. That it's not like 7 years she kept going to the religious groups every day, every day. They tell her, no, divorce is not good, And it's in another video, she actually shared that it was until someone from the religious group who saw her in Burqa who said, no man, this woman is really, really abandoned, right? So, and had that man not seen her, probably till still today, she'd probably still be married to her ex-husband. So I think that's why it's so important for us to have these advocacy campaigns and try and educate and have information readily accessible to our communities to ensure that they don't go through what they actually went through, right? So yeah, so the hearing for the Besta matter will hopefully be next year. We're currently awaiting a judge to be allocated for the matter.
Hi, I just wanted to ask, from the time he abandoned them to the time she got the fasakh was 7 years. And during that time, she was in and out of the different councils trying to get the divorce. Did he refuse to give her a talak when he left? And then he just went missing.
Yes, he definitely refused. Yeah, he refused.
It's common.
And
It's
did
crazy.
not
It's
pitch
common.
every time the religious body called him to come give his side of the story. So he would not arrive at all. So that's how she ended up then giving up.
And even though it didn't pitch, they did not give her a fasach.
No, they did not. It was until someone from the religious body in Burkap saw her really struggling. That's when they said, no, she's actually not lying. And that is the issue that we have in society, right? That we don't believe women, right? And there's that notion that we don't believe women. And also the notion that Black people can wait, right? And that is something that like is very important for us to highlight, to say that, but you know, we need equal access.
I agree. I was in a similar situation where I was pregnant. We were only separated for a few months before I found a mufti and I met with him. And they gave me a fasach after speaking to my now ex. And my ex said to them, "You can give a fasach because I'm not going to give a talak." So I understand, but 7 years is just so ridiculous.
Yeah, I think also there's another clip as well. So last week we had a community workshop in Mitchell's Plain, and we actually have one of the women who shares her story. And one of the things that she shared, but you'll see in the video that we're going to play later, she says that her husband got a fraudulent talak. The certificate was not even signed by anyone, and he used that to bully her out of the marriage, and she just ended up giving up, right? And I think that's the thing, even with like recognition of customary marriages, women end up throwing the towel. They're like, I can't do this, you know, and that is something that we try as much as possible to address when we do our litigation. That's why we center women's lived realities. And we always come with case studies to say that, because you'll see later in my presentation where I talk about how by the time they launched in 2014, they had about 800 women that had approached the court. So someone had to listen, right? But also it should not take 800 people coming you know, for us to have equal access and non-discrimination. Yeah. We have another hand.
Thanks.
Is it on? It's supposed to be.
I'm just interested, how is the education and advocacy going?
It's really going well. So we dedicated the whole month of September to these campaigns. So we put them on TikTok, on Facebook, and we try to break it down in a language that even community members can easily understand. And we wrapped off our campaign with a community workshop in Mitchell's Plain last week. And I must actually just say that we actually have men allies in the Islamic community, because we had men paralegals in the workshops, and they actually expressed that no, we definitely need this recognition, because people are practicing as though they don't know what the Quran says, for example, right? So, and I think it's something that Aisha also highlighted, to say that the Quran talks about kindness, it talks about sympathy, but when you actually like implementing it or living your daily life, you actually forget about those values that you have, because you're using it to then silence women and oppress women as a result. So we are definitely still continuing. We've made in 2023, we made submissions to the draft marriage bill. We made submissions to the divorce amendment bill. We also made submissions again last year before elections to the final marriage bill submission. And then we're going to then participate in November in the public participation process that the portfolio committee is still having. Yeah, and what we do, we also have pamphlets as well. And we have what we call legal advice units, where there we have a dedicated month where we unpack frequently asked questions that we get from our law clinic. So every Monday of a particular month, we'll then answer questions as easy as possible. So we definitely still putting the pressure, but we also just doing our best to join hands with communities and ensure that this information reaches as many people as possible. Right? Is there anything online? Nothing online. Okay. We can break till 11:30.
Hello, can you hear me? No? Is it on? Speaking louder? Yeah? On that side, okay. Okay. When you're ready, I'm gonna switch it off. Yeah. When you're ready, just. Sure, okay.
There we go. Off the line. It's an emergency. Yeah, but it's Apple, which always gives a problem. I know. Yeah, I know. Apple always gives problems to everybody. But I don't have an email.
Hi, everyone. Please take your seat. We're going to start shortly. So our next speaker will be presenting on the intersection of Islamic law, gender, and feminist legal theory. Prof. Sidat is associated with the University of the Western Cape, and as I briefly mentioned, she's the expert that we relied on her knowledge and expertise in the Besta matter. Thank you so much, Prof. You can take the stage. And maybe just to also just say that for the online participants, please feel free to send any questions in the comment section or raise your hand if you would also like to engage.
Fatima, I'm not that old. No, I can stand, it's fine. You hear me? Let me know at the back. Muniba, can you hear me? Okay, great. So I'm using this other mic here. And just a clarification, I'm at UCT, not UWC. I don't have the privilege of being at UWC. Who chuckles like that? Thanks, everybody, and thanks to the Women's Legal Center and Fatima for the invitation for this event. I want to say thank you. And I think just in terms of what we'll do today, what I would like to do is shift a little. So you're all practitioners or working with the law in a very applied way. So I want us to just take a bit of a shift, ask you to shift your mode for a moment, and we move more into a theoretical kind of a space. A little to talk about Islamic law theoretically, and a little to talk about feminist legal theory. How do we bring it into Islamic law? Because much of the challenges, we heard Mrs. Best's story, and that story is the way it is because we have a particular reading of Islamic law. And much of the reform we have to do in order to move this and to bring it into conformity with South Africa's constitutional context is largely the application of feminist legal theory. Now, the big question is, how do you do feminist legal theory as Muslim women? And the answer is there. We've been doing it, we keep doing it. In fact, a lot of the coming to the place we are right now is the result of feminist interpretations of Islamic law that didn't begin yesterday, that we've been doing this for a long time ago. It's about recognizing that and also bringing that into your legal practice as an awareness and a consciousness, that you're not stuck in a sense of Islamic law only allows out of community or property regimes. We step out of that kind of thinking as well, but to give you the tools and the energy to step out of that kind of thinking. So can I start my 20 minutes now, or have my 20 minutes already started? Can I start it now? Okay, great, thank you. So in terms of what we'll do today, we'll do a bit of an overview of gender-based reform in Islamic law. So you know that this gender-based reform has been going on for some time, and you can know what it's about. Then I talk a little about gender and legal capacity in Islamic jurisprudence, which we call usul al-fiqh. But we talk about the idea of the individual. Who is the individual? Who's the legal subject in Islamic jurisprudence? I end with two propositions. One is to advocate to recognize women as full legal subjects in Islamic law, right? The second is to shift our understanding from who we're working with that we're not working with women in Islamic law, but in marriage law, we're working with wives. But to shift to the idea of a wife as opposed to a woman. And in that, my proposition is to consider wife as a legal situation, as a contracted legal position, legal situation, as opposed to an essence of wife or an essence of woman. The wife being a legal situation one contracts into. Conclude, I want to offer that we adopt a feminist posture in litigating Muslim personal law matters. A feminist legal theory posture or feminist law posture when we're doing your litigation. And I think to start with, I'm not only part of UCT and African Feminist Studies Department, I'm also part of the Muslim Personal Law Network. And the way Charlene earlier said that Women's Legal Center is not Islamic, it's not Muslim, and they don't do Islamic law, I think we can very firmly say that the Muslim Personal Law Network is a feminist Islamic law space. This is what we do. And we've been doing this for a time now. Formally, we've been doing it from 2016, but more, prior to that, when we were talking now, when Charlene was talking, I remember doing this at the time when Women's Legal Center started. It was the 90s. And I checked my computer just to get the dates right. We have contracts, Islamic law contracts that we were doing already early in the 90s. So it's a long process. Technically, even if you count from 1994, we've been at this for 31 years. And what that means is that it needs to shift. Things need to move. But of course, we're sitting with a situation where there's so much reluctance within the state. And for that, we have to speak to the way in which the state is not willing to engage religion. Charlene came to it at some point, to some degree. But I think that's something we really have to work with. Why does the state treat religion as it does? And what happens when it does this? When the state treats religion as something that it cannot touch, it does not touch it. What it actually does is it keeps the way religion has been framed in the mainstream, it keeps that as the status quo. So the state is not engaging religion. It's ensuring the continuation of the status quo. And that is our problem, because the status quo is problematic. So we move from the idea that the state is not engaging, and we call the state out to say, what you're doing is you're maintaining the status quo. And the status quo is that women find it impossible to leave their marriages without fasakh. It's that women don't have property rights, women are struggling to have maintenance. You're actually maintaining that status quo. That's just to clear up some of the fluff that sits around us. To begin with, gender-based Islamic law reform. But I see I have this slide. Let me just do this slide first. This is something the Muslim Personal Law Network put out in 2021. Authored anonymously. It was 50 steps on how to leave a Muslim wife destitute. We wrote it because this is exactly what happens in our communities. So we were calling it out, right? And our steps go from something as simple as marry a woman in Islamic rights only. If she asks for a civil marriage, tell her it's haram. We can rely on the Sharia to protect us, right? Because that's what happens. If she insists on an Islamic marriage contract, ensure it's not in community or property. Pretend like that is haram. Pretend like that is forbidden for her because she's a Muslim, because it's not forbidden. Make sure you get to choose the imam for the nikah. Her imam might insist you register a nikah as a marriage through Home Affairs. Don't do it. And if your imam suddenly develops a conscience and requires you to register the marriage, then remember you can always stall. And they do. This comes from exactly what experiences we've had. So this was a real tongue-in-cheek way of saying this is what's happening and how do we address it. Come to some of the final things. Don't feel guilty if after 10, 20, 40, 50 years of married to you, your wife will have no assets to show for the time and effort she spent caring for you, the family, and the home. And don't feel guilty. Keep pretending that this is what Allah wants, and keep pretending you're just doing things the Sharia way. So that's what we're doing. We're calling this out and saying this is not the way we understand, the way Muslim women understand Islamic law and the benefits of Islamic marriage, which is why we do it. And the idea is to call it out and say, this is not how it is, this is not how it happens. Take you now to this little aspect. You might recognize this. Remember the Muslim Marriages Bill 2010, long ago? Well, Women's Legal Center will definitely remember it. It gave us nightmares way back when. It was an important aspect of this that was shifted. An important part of this was shifted way back then. The original asked for, that said a wife and a husband in Muslim marriage are equal in human dignity and both have, on the basis of equality, full status, capacity, and financial independence, including the capacity to own and acquire assets and to dispose of them, to enter into contracts and to litigate. When the United Ulama Council looked at it, they offered an amendment which took out the underlying section. It challenged the idea of, on the basis of equality, full status, and capacity, because they don't see it like that. They're willing to have everything else, but not with the presumption of full status and capacity and equality. Now, that's at the crux of discussions that have been happening throughout the years, whether women have full status and whether they can have equality in Islamic law. Some of the work that's happened over the past 40 or more years, scholarship on women, gender, and sexuality in Islam has developed in various ways. And there are different narratives of gendered legal subjectivity. There are three key approaches to law reform, and at least what I see as 4 discernible narratives of sex difference that have emerged in the study of gender in Islamic law. While they indicate toward the richness and nuances of this field of work, theoretically, they also indicate a move beyond the deconstruction of a received notion of Sharia. And this is really important. When we're engaging with Islamic law, we're actually challenging this idea of Sharia as given, unchangeable, unshifting. Because that you might often have been told, you can't change Islamic law. It is what it is, nobody can change it. They have to do what's in the law. And much of the reform work has challenged this idea that Islamic law is unchangeable. And so, and the way in which it works is to take out the idea that that Sharia is this hard kernel that you cannot touch. And I say we've popped the kernel like a popcorn. We've said this is a popcorn. You can touch this kernel. When you pop it, you're going to see the insides of it. And when you look at the insides, realize it's multiple, it's multifarious. Every time you pop, you're going to see something else. So it's about looking inside the law to find what is possible and new and changeable within the law. There's 3 approaches to gender-based reform. They do it, some scholars have done it by offering different interpretations. So reinterpreting law, giving an interpretation of marriage, which was historical, giving new interpretations which would highlight the space of the contract, the way in which the contract can and cannot work. And then there's work that has done deconstruction. And part of that deconstruction is to deconstruct, for example, the idea of marriage itself. What is marriage in Islamic law? What could it be? What are the potential ways in which marriage can happen? Who has what power and what right within the marriage? Other ideas of deconstruction have been the kind of work around legal capacity. Understand what is a woman's legal capacity? Who is a woman in Islamic law? So to unpack this idea and coming to the idea of woman as wife is one way of deconstructing it. Another form of law reform that we've seen is a shift to ethics. So part of the struggle in a Muslim minority community is that we don't have a formal court with which to hold someone accountable to Islamic law. And so a lot of the accountability is an ethical accountability, which we hope people will hold within themselves as pious individuals. If you're a religious individual, you have a fear that your relationship with God will be compromised if you are not a just person. And so we work on the ethics. So there's a lot of movement gone to the ethics. What kind of ethics does a person hold? And then there are at least 4 narratives of gendered legal subjectivity. You'll often hear people say that women and men in Islamic law have complementary roles. So women have one role, men have another role. They can't be changed, they can't swap. They're complementary, they balance each other. So there's the complementarity narrative. There's also a rights-based narrative, which is part of the reform narrative, which is Muslim women have rights. And so the rights-based narrative, it's not new, it's been historic. Muslim women have been engaging with UN instruments. And in South Africa, we have a rights-based narrative as well that comes out of the Constitution. There is a disability narrative which precedes all of this. This is the idea that Muslim women have a disability in Islamic law, in that they are not the same kind of subject as men, and so they have a legal disability. There's another narrative which is more recent, and this is the narrative which I want to talk about, which is to separate women from wife. Separate the legal subject of women from a legal subject of wife. And that's the work I'd like to do and take you into some of that now. To do this, we can use some historical feminist legal theory. Sexing the Subject of the Law is a 1980s, 1990s feminist legal project that worked on examining the legal person as opposed to a legal woman. Who is a legal person and who is a legal woman? Works with the idea that the neutral subject of law is in fact heavily endowed with masculine characteristics, right? You'll remember this from your law lectures. And it is the male person that is the normative subject of law. The male person is considered the normative subject. Women are considered non-normative subjects. When we talk about women, we're not talking about the normative subject. The question is women included in the concept of the legal person? Now, there's a good amount of literature and feminist legal theory that you can go and look at, some very cutting-edge literature. One example, for example, is when a woman is pregnant, how many legal subjects is she? At which point is she one legal subject? At which point is she two? Is she always ever one legal subject? So questions like this will give you an idea of how the normative legal subject is generally male. Judith Butler is very helpful here, and she tells us that juridical systems produce the subjects that they eventually come to represent through exclusionary practices that do not show after they've been established. So rather than say that the law gives form to a woman that exists outside of the law, we work with the idea that the law produces the idea of woman. It's law that produces the idea of who a woman is in law. We don't have a woman that first starts and then law comes up and says, oh, this is who she is, we're describing her. No, we work with the idea that law produces the subject. This is a very powerful idea. Legal texts produce legal subjects, even as they ponder them. The legal subject doesn't exist before or after the text, but covalently with the text. So the text produces the subject. This is some of the theory we need to keep in mind. To work with this, if we move to the idea of legal capacity in Islamic jurisprudence, we come to who is the woman of Islamic law. So legal capacity in Islamic law is the idea of sufficiency to contract and to act. There's two aspects of it. In Islamic law, it's determined by sufficiency of mind and sufficiency of the body. The body becomes legally accountable when it reaches puberty. The mind when it reaches discernment. These two aspects are what make a subject a full legal subject in Islamic law. This is what makes you accountable. It's composed of the capacity for obligations and the capacity for acquisition. You will know about these capacities in your own study of law. There are various opinions as to whether women have full legal capacity or not. And I just have two slides. You don't have to read much of them, just to know these two names. These are two scholars, Ahmed Niazi and Mahdi Zahra. And basically, Ahmed Niazi and Mahdi Zahra are two contending poles of the discussion as to whether women have full legal capacity or women have compromised legal capacity or deficient legal capacity. We won't get into detail because I'm watching time. The question that we ask is, does sex difference determine legal capacity? A really nice scholar who's written a book on desire. And she observes that gender is not the sole determinant or social marker in legal discourse, but it functions alongside and intersects with other systems of distinction and social identity. You'll all know this as a theory of intersectionality, right? We don't just work with gender, there are many other markers that we have to work with. So this idea of presence or lack of gender as a distinctive category in legal capacity is something that comes and goes. And I argue that the female legal subject is not simply or singularly constituted as women. This is an argument that comes from the fact that if you look at Islamic law, there are some places where women have similar rights, some places where women have very different rights from men as legal subjects. And so this is an argument that we can't look at women as the subject of law because it's so different, it's so distinct. And I want to take you to this. These are the impediments to legal capacity in Islamic jurisprudence. So this list of 16 things there. If you go through all of that, you can see what makes you legally less capacitated. Do you see women in it? Is it too small? Can you read at the back? Yeah. Can you see women in it? Of course you don't. You see something womanish in it? Yes. What's womanish? Right. Sorry, I'm a lecturer, so I'm doing this to, forgive me, it's my default. So what's womanish is menstruation and postpartum bleeding. Let me take you to exactly that place in Islamic jurisprudence where it speaks about menstruation and postpartum bleeding. And I'll read it for you. I would normally ask a student, but I'll read it. Neither menstruation nor postpartum bleeding negate a woman's legal capacity. These two conditions only affect a woman's capacity to be in a state of ritual cleanliness for prayer and fasting. However, this does not affect either her capacity for obligations or her capacity for contract. Clear? How old is this text? This is a 13th century text. It's not from yesterday. This is a 13th century text. And this is what I'm saying. This is the kind of consciousness we need to bring to the litigation. To say what we're seeing right now is very modern, it's very new, it's very specific to what people are wanting to achieve now in terms of discrimination. But it doesn't have a historical precedence. That's the same thing. And so the argument is that classical jurisprudence does not include gender or being a woman as a legal impediment. What does determine gendered legal capacity? And my response to this is that legal situations determine legal capacity. So what do I mean by legal situations? So for example, if you take the idea of representation, having an agent on an issue, a proxy to represent you in court, for example. Classical law says that when a man wants a proxy in court, the opposing party has to agree to this proxy. Women don't have to have that agreement because it's assumed that women will not want to be present in court. So there's a place where you have something that may be facilitative or it could also be detrimental. But what's happening there is that that woman is now in the situation of having to represent herself in court. It's that circumstance of being in court that is being determined. It's not her womanness that's being determined. Similarly, a woman may own property, sell property, because she has legal capacity to own. So it's not womanness, it's being an owner, a proprietary owner that is determined. And so through this, we can go through many, many aspects of Islamic law, and we come to marriage. We find one of the legal situations is wife. And that is a contract you enter into. And we can argue that the situation of women in a marriage is not the same as the situation of a woman outside of a marriage. So for example, when I'm married, I would have certain constraints about me in terms of what I can act, how I can act with regard to my marriage contract. But those constraints don't apply in terms of how I can act when I'm selling a piece of land. Those are two different things, right? But what happens in my marriage contract is determined by the contract itself. And so, what happens when we shift focus from women to focus on wife? Firstly, we move away from the idea of an essence or an essential definition. We move to wife as a situated legal position. It's not permanent, it's not essential. We recognize legal situations rather than biological essentials, right? And this allows a single individual to have multiple legal capacities in different places, in different legal situations. We recognize that the legal understanding of woman is not singular, static, essential, or substantial, but it is multiple, moving, discursive, and situational. What does it mean for you as practitioners? I said I would come out of my theory space into a very practical space. As practitioners, it means you may adopt a feminist posture in litigating Muslim personal law concerns. Because when we do the feminist reading of Islamic law, here are the options. There are options, right? We need not sit with the presumption that to be a woman in Islamic law is to be naturally embedded in a series of restrictions. We need to take a different posture. We need to work with the idea that a woman is a full legal subject. And then when we work with the idea of wife, we can talk about what kind of a legal character subjectivity is a woman shaping when she enters into marriage. And if there are no contracts, also what has been shaped by virtue of the context. And we have in South Africa the context of the Constitution. And that too must inform us, it has informed us, as we're thinking about what the capacities or incapacities are of a Muslim wife. Did I do that already? Yes, I did that. So just to bring us into some of the work for, I think I'm over time, I know, but can I just have 3 minutes? So this is the kind of approach that the Muslim Personal Law Network has been working with. And I should have said who's here from the MPL network. Nasima Hassan is there, Aisha Roika at the back, I think Romana Mohammed is online. So these are people who, if you're looking to refer to for how to think about Muslim family law matters, these are the people you would refer to because they're already doing this work. And this is just to show you some of the work, the ways in which we function. So one aspect of it is in terms of the framework for reform that we use. The framework for reform that we're using is a triple framework. We work with the idea of engaged surrender, which is a pietistic, it is a way to engage religion. It's engaging the Quran, it's engaging Islamic law in a way that says we are believers and we are engaged in our beliefs. We're not taking beliefs that have been given to us and saying this is how we're doing it, or that we'll do it as we're told. We're actually engaging and having the discussion to say, this is what we see our surrender to God as in this engaged way. So we're engaging, we're talking, we're opening things, we're closing things, we're moving. The idea is activity. The second aspect is the idea of practice, a hermeneutic of practice, a tafsir of praxis, which is informed by Sadia Sheikh's work, is a hermeneutic of practice. So we're doing interpretations that are informed by lived experience. What are the lived experiences? So if we take Ms. Besta's work, her experience, whatever we do in terms of a response to her must be informed by her lived experience, because ultimately we want to ensure justice for every believing woman. You don't want it to be that because you're a believing woman, you should not have justice. So it must be informed by experience. The third element of our framework is the idea of full legal capacity. And to separate out the idea of wife as a contracted legal capacity, a contracted legal situation. It's not given, it's not predetermined, it's how you're going to contract into it. So some of the things that we're able to do, some of the work that we've been able to do with the Muslim Personal Law Network is to reconsider how people enter marriage, how they exit marriage, and issues of inheritance. In terms of entering marriage, we're interested in contracting into marriage with conditions. And so we speak about the marriage contract. How will you contract into it? What conditions will you put down? And to let women know you can do this. You can put down the condition that there will be no polygamy. You can put down the condition that you will be able to exit on your own will. You have a delegated talaq. You've all heard those words, talaq, he gave a talaq, or he won't give a talaq, and I want my talaq. The idea of a delegated capacity to talaq is something we also work with. You put these into your contract, give you a right to exit. And then a condition about the property regime, that you can choose it. There is no default that you must adhere to. You can choose it. It's a negotiation. And so to get out of everybody's mind that there's only one way in which to contract property in Muslim marriage, it can be negotiated. Then there's the mahar, which is the bridal, which is the gift at the beginning of the marriage, that too can be used as a as a form of leverage. You can have an immediate one, you can have a deferred one, you can have one that's payable upon divorce and death. These are all options. In terms of exit, we've been working with the idea of delegated talaq, and we've been working very strongly with the idea of khula, as where a woman initiates the exit. The dominant discourse is that a man must agree to it. We take the opinion that a man need not, that a woman can exit on her own capacity, exit. And it's not new, we didn't innovate it. There's a lovely man in Johannesburg, Abdul Qadir Abdul Samad, him and Mr. Mia, I think in the late 90s, started something called the Khula Society. And we learned from them how to do this, and we've been doing this. There's the way of using the parting gift, the mata, which is a Quranic concept, so that at the end of the marriage, you can have a form of a lump sum payment to facilitate the woman's the new life, just transitioning into a life outside of marriage. A lot of women have been working for 30 to 40 years in the home, do not have skills, need to reskill so that they can earn a living. The idea that spousal maintenance is an exclusive husband's responsibility. Child maintenance as well is an exclusively husband's responsibility, 100%. So to put those into your negotiated divorce agreements. In terms of inheritance, it's not un-Islamic to negotiate equal shares during a lifetime, and then to develop strong systems of estate planning. Those are just some of the ways in which Muslim Personal Law Network has been working. And I think I can stop there. Okay, I've gone way over time. So sorry. For 7 minutes, my apologies. I stay here?
Thank you. Thank you so much for that brilliant presentation, Prof. I wanted to check, does anyone have any questions for Prof? So Charlene and Prof are clearly clear. Oh, Charlene has a question.
Yeah. We did a feminist clinic, or we do a feminist clinic every year where we take young law students for a couple of days and we talk about feminist litigation and kind of how WLC does it. And one of the things that came up very strongly this year was the way in which the law is taught. And that the law very often is taught to students as being cast in stone. And how do they as law students make the shift? And I think that sometimes that's the same question that we can ask as practitioners is how do we begin to make the shift of looking at the law as something that is either on paper cast in stone or non-existent, and therefore those rights don't exist. And I'm sorry, this maybe isn't even a question, but just something that's come up during the course of you talking, is just this idea of where, you know, we have legal practitioners in the room and online, and how as lawyers, we look at the law, and we look at the client situation and the problem that presents itself, and how we're often limited by our own training to be able to provide solutions or come up with creative ideas. And I think that that's something that you've illustrated. So the network that you've been able to do, and that some of those things are out there, and that it's important for lawyers to be aware of it. Thank you.
Thank you. Just gonna double check if there are any comments. Line. No comments. Nothing. Okay. I don't know if Prof, you'd like to reflect on Charlene's input.
Sure. I think you're asking about how do we make the mind shift, make the shift in our minds to using law in ways that are responsive to what our clients are asking for when that request doesn't appear to be apparent in the law. right? I think um, I think it's important for us to be guided by that sense of justice or injustice that the client is experiencing. And I often say for many women, there's a dissonance when it comes to law. We are schooled into the idea that law gives justice, but frequently law gives women injustice. And it's through the application of law that injustice is realized. And it's because the primary subject of law is not the woman of law. The primary subject of law is a normative male subject, and the reasoning of law is male reasoning. So, and you see it immediately when you come to issues of pregnancy, when you see the individual is a different kind of subject from a normative subject. But that shouldn't only mean that only pregnant women should have that way of thinking applied to them. One of the ways in which feminist theory generally directs itself is to look at the locations of power in a legal situation and to see how power is being used to continually produce injustice and what shift in power needs to happen to produce justice for your client. Importantly, and I think this is important for anywhere we're looking at tradition or culture or religion, we cannot impose the conclusions that we want upon communities. Those conclusions have to come from within the community. And we've seen to a large extent in South Africa, South African Muslim women have been advocating for all sorts of equality in the application of Muslim marriage law. And so it's perfectly suitable and appropriate for the state to be directed by that. But we have a situation here in South Africa where the state says, no, there's no consensus in the Muslim community. And that's because they're looking for consensus from the religious authorities. And the religious authorities, I don't know one that's not a man, right? So if that thinking and the motivation is coming from the religious authorities, we're not going to see the kind of justice and relief that we want. So what does it mean for South Africa if that's the situation? I think we need to, and you've said you've had male allies. The important thing is to show the religious authorities that this is actually in the interest of the community generally. To have equality and to have a sense of justice by following your religious law is beneficial to the entire community. It's not just beneficial to women. The problem is that it gets seen as a zero-sum game, that if women have rights, men don't, right? So I don't think I have a solution or anything for you, Charlene, but just to say that this is something challenging that we have to do all the time. And I think we don't do enough feminist legal theory work. I think we need feminist legal theory summer school. You know, that's the kind of work we need. We need feminist law summer schools. We need summer schools that talk, we need courses. We need to be teaching. We need textbooks. There's a lot that comes out of Australia, New Zealand. I don't know if you've seen the literature there. There's a lot of literature that comes out of Australia and New Zealand on gendered legal subjectivity, on women as subjects of law. But there's very little that we are doing at the moment. And I think we've got a lot in South Africa to use as material to start writing and thinking about this. We have to shift this, the narrative.
I just had a question about how do we shift the narrative from the male subject of law to women, and then also how do we incorporate Sharia law principles into South African law? Because what I've noticed and what I've come across is that there's this idea that Sharia law is not woman-centric, doesn't protect women. How do we shift that, change the narrative to apply Sharia law correctly to South African law?
I think the important thing when we look at the idea of Sharia is to understand the concept as a discursive concept. It is something that we're producing all the time. What Sharia looked like in the 11th century isn't what Sharia looks like today. And what it looks like here isn't what it looks like in Lebanon. shifts and it moves. But we have this false narrative of it being a singular thing that existed in the same way all through time. So that's the first narrative we have to shift, that it isn't singular, it isn't uniform and universal in that way. Certainly not when it comes to marriage and family law. And so we also have to make the distinction of what is Sharia and what is what we call is a positive law and jurisprudence, or fiqh and usul al-fiqh. These are all terminologies. And I could continue through all the technicalities of it, but the important thing is that this must become work that we are familiar with. This must become knowledge that we are engaging with all the time. It mustn't remain knowledge that's exclusive to religious authorities. We've got to become au fait with it. It's got to be something that is as common to us as the idea that Sharia is unchangeable. We must shift that narrative to Sharia is contextual. Islamic law is, fiqh is contextual, usul al-fiqh is contextual. And it has always been contextual. The fact that it is the product of the human intellect means it's always going to be changing. It's always going to be, and it should be responsive. In terms of bringing it into South African law, there's work around the objectives of Sharia, maqasid al-Sharia, which people use to bring it to find relevance with South African law, and in other minority communities to find relevance. I think the primary way to bring it in and to make two systems talk together is to actually have people talking who know both systems and who are interested in both systems. And that means everybody must be available at that table. It mustn't only be the leaders of religious organizations. And that also requires those people who don't look like them to go out and learn, go do the study, and don't be afraid to do the study. Go and put yourself aside. Well, that's the thing. No one's going to support you to put yourself aside for a few years to learn. There's lots of scholarships for men to go to Medina and to many other places to go and learn, much fewer for women to go. So that's an issue within the community about creating learning opportunities and education opportunities for young women to go out and to learn the Sharia. The problem is, I don't know one school, maybe there's newly, but last I checked, I don't know a single school that teaches Islamic sciences that has the same curriculum for men and women. We're still sitting at schools that teach Islamic sciences with different curriculum for men and women, the traditional schools. So I can go and I can enter into a traditional school to teach Islamic law, but the curriculum I'll have will be different. And the only reason I know what I know is because I made my own curriculum. And there are other people in the room as well who've gone and made their own curriculum and found their own curriculum. So it's an education, it's a structural and systemic issue. But I think the important thing as South Africans is that we don't have to be bound by that. We can and should be guided by our constitution around issues of equality. And so long as there's South African Muslim women who are making arguments for this equality, we should be listening to them. We should be guided by that. Good.
Thank you so much, Prof. Thank you everyone for engaging. We can give Prof another round of applause. Thank you so much. So in the next section, we'll be looking into legislative developments on equality and relationships. I have a short presentation and it will be followed by Aisha, who will take you through her thoughts. I'm just waiting to get set up and okay, so at the Women's Legal Center, we have a focus area that we call equality in relationships. In most firms, the focus area would be referred to as family law, the family law department. But we call it the equality in relationships focus area because we want to ensure that all relationships and families in their diversity are legally recognized, respected, and the rights of women in these relationships are protected, right? So you can be as diverse as you want. So we don't believe that women need to be married or be in a particular setup for them to have legal certainty about their rights. And this is what we achieve through strategic litigation, research, participating in law reform processes, education, as well as training. So we use a tool within the WLC that we call intersectionality, right? And for us, this is particularly important because due to South Africa's apartheid and colonial past, our current family laws, we believe that an intersectional and gendered lens are critical, are critically important as a tool by which one needs to analyze the experiences of women and to develop laws and policies that speak to their lived realities. So yeah, so we're one of those lawyers that are quite obsessed with women's lived realities. We literally say it at the end of every sentence. And this is something that is very, very important for us because we know what the impact that patriarchy has had. And I mean, even now, Prof. Sidat has even said that women and men have different curriculums, right? And it just shows you how far deep patriarchy actually is embedded in different systems. And the main thing is that we acknowledge that as women, we are not a homogeneous group, but we are made up of diverse intersecting identities. And therefore, one uniform or one blanket approach would be a narrow way of addressing issues that women face in family law in particular. So women have various intersecting identities within which their interpersonal relationships, within their interpersonal relationships, their homes, families, and communities, as well as their workplace. So I will give you a brief history of the Muslim marriage bill. I know Prof touched briefly on it, but I felt it was just very important to give the history of the bill because it then shows us that the recognition of Muslim marriages was not just started in 2014 when the WLC actually launched the case. There was work that was being done in the background. So I think we can all have a consensus that most marriages in South Africa were in principle recognized, right? But due to the legacy of apartheid, there was no legislative framework within which it formalized or entrenched recognition. So we then had a situation where we allowed people in either customary marriages or religious marriage to do what they wanted to do, how they wanted to do it, without us having a pronouncement on recognition and without any legal certainty. And then we had these people getting married, but their marriages were not even being registered on the National Population Register. So you just got married in your culture or within your religious beliefs, but there was no protection for you actually beyond that. So we then have they then had at the time, I think I was still in grade 3, they so in the year we have two drafts of the Muslim marriage bill. We have one that is from 2003 and we have one that is from 2010. And one thing that is very also important to just mention is that from the two versions that we had of the Muslim marriages bill was that the 2003 marriage bill had the support of the ulama, right? But the state then amended it. And that is when there was like a break off and a divide, right? Because they felt as though that the law wanted to take away their role, for like a lack of a better word. So there was really no consensus at the time. And even within this consensus, we have scholars like Prof. Wahida, who then also says that, but if you were able to recognize customary marriages, which allow for polygamous marriages, why can't you use the same section in the constitution to do the same with Muslim marriages, right? But it's essentially because nobody really wants to rock the boat when it comes to religion. We just constantly want to, we tiptoeing around it. But I think more than anything, it was the political will. There actually was no political will because the reason some of the biggest reasons why the ulama was really against the 2010 draft bill was because they were insisting that women needed permission from their husbands to divorce them. But that then takes away the woman's agency to choose, right? Because if I want to terminate my marriage and my husband doesn't want, then it means that I'm trapped in that marriage and that the law actually has made a pronouncement on that. But because we live in a democratic society where Section 9 of the Constitution takes preference, it was just not going to be possible. So these are the kind of things that they were battling with the two bills. And I think another one that is really worth mentioning was that they also wanted like to have compulsory mediation, right? That if your marriage ends, you must have compulsory mediation. But then it was the feminists came out and said, but no, we don't want that. You know, I don't want you to convince me that what I'm doing is right or what I'm doing is wrong. And we also see this through Ms. Bester's story, where she constantly went to the religious body to get her divorce, but they kept telling her that, no, man, you know, give him a chance, you know, maybe he's going through. So there's always excuses on why the man is not fulfilling his obligations, but then women have to then be subjected to that and then still struggle in the long run. So that was one of the key disagreements, which led obviously to the abandonment of the 2010 bill. And we didn't see anything until we got to a point. We got to a point where WLC litigated the, we call it the MPL matter internally. And I think Charlene had gone very deep into this conversation, but I just wanted to just give insight on the timeline to, they were given a choice to either enact new legislation or amend existing legislation. And the initial timeline was June 2022 to June 2024. And before the elections in May last year, I remember it was the 2nd of May when the Speaker of Parliament filed the urgent application to say that they're requesting for a further 2 years in order for them to finish with public participation and giving an update. So we didn't oppose as the Women's Legal Center. We chose the route of abiding with the court decision, and then the Concord then gave the extension. But it's also very important to just get a bit deeper into the piecemeal approach that Charlene spoke about. From 1999 to 2014, the WLC undertook piecemeals where we were essentially talking about recognition, but I don't think that people, well, the courts and everyone else were actually alive to the fact that this is the bigger thing that we want, and if you give us that, we'll get it. So we ended up litigating small cases that we were able to refer to in the bigger case. So we then have the first case where we litigated whether surviving spouses of monogamous marriages, Muslim marriages, and polygamous Muslim marriages are entitled to inherit in terms of the Interstate Succession Act and the Maintenance of Surviving Spouses Act. And then we also then litigated whether a woman in a Muslim marriage can claim loss of support on the unlawful death of her husband. So this is in relation to your RAF matters. And then we also litigated a case whether a husband may obtain an eviction order to evict his wife, to evict his first wife and children from the matrimonial home. And this also goes back to how women are so vulnerable and how without recognition, they're actually left destitute. And then also, we then had a matter seeking relief to protect women in Muslim marriages and children born of such marriages with legal protections, primarily at the dissolution of the actual marriage. So it is also noteworthy that we had about 800 women that had approached the WLC at the time before this case in particular was launched. But it's also very important to also highlight that the women that approached the WLC were well into their old age. They had no prior education, and they were not aware of what their rights were at the time. So that was the kind of profile that was litigated in this matter in particular. And that is who we presented to the court to say, these are the most vulnerable, and if nothing is done, they will be left destitute. I think we went briefly, Charlene spoke briefly about the timeline and what it took. So I will speak about the 2023 public participation. So in 2023, we had two processes. So in 2023, we had the first side of the draft marriage bill. And then it was then followed by the Divorce Amendment Bill. And then, so the Divorce Amendment Bill went to be signed by Cyril Ramaphosa a week before elections. And then we then had the marriage bill, the final marriage bill, circulated in December. No, it was actually early last year, because I know the closing date was in April last year. So those are the law reform processes that the Women's Legal Center has actually participated in. And just to also note is that, so like Charlene mentioned, it's the marriage bill is an umbrella term. So DHA then took a stance that instead of enacting or amending existing legislation, they're just going to go for an approach of actually having the marriage bill with a civil marriage, a civil union, customary marriages, religious marriages, all in one. However, there are overarching concerns on the marriage bill, and that is the reason why we also then abided last year. We didn't oppose, because had we not had we opposed, they were going to come back and say, yeah, but they're interfering, and you need like we had this we had this in the pipeline anyway. So we just abided, because we know that the marriage bill in its current form will be highly litigious, right? Because it actually takes us 10 years back into time. It's not a progressive document. So we have noted and pointed out to the portfolio committee that we can't have the ongoing of omission of recognition of life partnerships or domestic partnerships. And the marriage bill does not reflect the ongoing challenges that women have when they register their customary marriages, right? Which could also potentially be an issue for women who want to register their Muslim marriages as well. And then there's also an omission of Act 49. So Act 49 is the Sex Descriptor Act, where trans persons are able to change their gender marker as well as their names. So why this was actually important in particular is that civil society had organized and ensured that Section 6 of the Civil Unions Act was actually declared unconstitutional, because Section 6 then gave Home Affairs officials the right to say, no, I don't want to register your same-sex marriage because I'm Christian, right? So this was then declared to be unconstitutional, but however, it has made its way back into the marriage bill. So that's why it was very important for us to actually mention that. And then we also mentioned that from the draft marriage bill and the final marriage bill, there was an omission on the application of the act, the age of determination, consent, and the age of majority. They do mention it in passing, but we think it's very, very important for the legislature to actually like define what this means, so that you don't have a situation where you're now going to Home Affairs and Home Affairs is just trying to decide how to register or how to apply the act. So we then move on. So to answer Masi's question, we don't have anything. We currently don't have legislation that recognizes Muslim marriages. At this point in particular, they only have legal certainty when their husbands die or when they wish to institute divorce proceedings. So then the Divorce Amendment Act, also to mention that the marriage bill is also a way for them to comply with the constitutional court order in MPL. So then with the Divorce Amendment Act, it gives all protection and procedures under the Divorce Act now apply to divorces arising from Muslim marriages. It then includes, which includes maintenance orders, custody and access to children, as well as the division of property, right? And it's also noteworthy to know that this amendment applies retrospectively to Muslim marriages entered into before the act, offering relief to spouses in existing marriages. And also noteworthy is that Muslim marriages are currently out of community of property in nature. And this is something that was not really addressed by the marriage bill. So the marriage bill does not have a default position. So currently, if you get married in terms of the Marriage Act or Customary Marriages Act, if you don't have an ANC, your marriage is going to be in community of property, right? But with the marriage bill, you get to choose. there is no frontal default position anymore. And I think maybe, I'm not sure, I was not in the legislator's head, but I'm really thinking it's because they didn't want to actually have the ongoing debate on why Muslim marriages are out of community in their nature, but there is no antenuptial contract. So sometimes people hide these controversial debates and they find the way to cover them up with policies. So yeah, so this is the end of my presentation. I hope it was able to give an update as to what is currently happening with our family laws in the country and what the next 2 to 3 years would actually look like if you either litigate in Muslim marriages, customary marriages, or civil unions. Thank you so much. And lastly, we're going to have Aisha, who will be presenting to us. Aisha is a practicing attorney at Parker Attorneys. She's the head of conveyancing there, and she's also a member of the Muslim Personal Law Network. We will take questions after Aisha's presentation.
Thank you, Kinsani, and good afternoon. Assalamu alaikum, everybody who's present and online. Kinsani has given you a nice overview of the legislative developments, and she's asked me to speak on a few points. One of it being, how do the recent legislative developments in family law advance or fail to advance substantive equality in relationships, particularly for Muslim women? And when we talk about substantive equality, it focuses on outcomes and lived disadvantages, not merely formal parity. So what key developments have we had, as Kinsani and Charlene have gone through previously? The Constitutional Court ruling in 2022, which found that the non-recognition of Muslim marriages violated equality, dignity, access to courts and children's rights, and ordered Parliament to fix the law. Then we've had the legislative follow-up with the promulgation of the Divorce Amendment Act and certain administrative steps taken by the Department of Home Affairs. The Divorce Act was amended to read Muslim marriages into important provisions. And as we know, last year, Home Affairs began issuing nikah certificates, which allowed the registration of Muslim marriages of nikahs in accordance with the RCMA, the Recognition of Customary Marriages Act. So what have these developments, how have they helped, assisted Muslims? Firstly, with access to court and remedies. And in terms of these developments, Muslim spouses and their children, and I say spouses because it extends to women and men. So Muslim spouses and their children, they can now access the civil divorce regime for claims for maintenance and other remedies, which previously were unavailable to those who only had unregistered nikahs. And that removes a huge structural barrier which we as Muslim women faced. We also now, these changes bring Muslim marriages within the Divorce Act's ambit, or the Divorce Amendment Act, and it enables courts to now consider redistribution, maintenance, and the economic consequences of unpaid care work, which disproportionately, things that disproportionately have benefited women. So we as Muslim women, stay-at-home moms, we had no way of quantifying our contribution to a marriage. So this actually is now a way that we can actually approach the court and upon proving to the court or showing the court that it would be just, fair, kind, and equitable, the court can then grant a redistribution of assets. Previously, without having any legislative framework which governed Muslim marriages, many women relied on a claim for universal partnership. And in terms of a universal partnership, we needed to prove three things. Firstly, that each party to that partnership brings something into the partnership. And it could be financial, it could be labor, it could be anything. The second thing that we needed to prove was that the partnership was being carried on for the benefit of both parties, and that the goal of the partnership was to make a profit. So in the absence of us being able to approach the court under the Divorce Act, this was one of the arguments that women put forward. And there wasn't much case law with regards to Muslim marriages, because those women who could afford to litigate, we've spoken earlier about the high cost of litigation. So those women who could afford to litigate ended up, after 5 years of going through, waiting for the wheels of justice to turn, settling the matter. And matters that are settled don't set a precedent for the next case that comes, it comes to the court. So one of the cases which we relied upon was that of the Butters case. Don't ask me to explain, to pronounce the other party, because I don't get my clicks correctly, so I don't want to butcher the name. So the Butters case was something that was very important. And in terms of that case, it was a couple that were not married, but that lived together. They cohabited for, I think, 20 years, and they had children. At the beginning of their relationship, the woman introduced her partner to people in his electrical business. So she brought him clients. That was her contribution. And over the years, his business grew, and they moved from, I think it was the Eastern Cape to Gauteng, and the standard of living improved, all because of this initial little electrical business. And after many years, when this relationship now soured and they went their own ways, she was left with nothing, because everything that he had acquired for the duration of their relationship was in his name. So she approached the court, and because they were not married, there was no legal framework which protected her, and she had to prove this universal partnership, and she was successful, but also at the court's mercy. And the court then granted her a 30% of the share of the assets of this partnership. So as Muslim women, our marriages were also not recognized, was not regulated. And this was something that we could use as a claim to try and get a share. But like I say, most parties settled when they were litigating. So there wasn't much case law relating to this. So registration of our marriages, it now means that the marital status is easier to prove when it comes to inheritance, social grants, medical, administrative purposes. And it's again a practical improvement for women and children who previously were living in this gray zone. Do we have a relationship? Do we have a marriage? Is it valid? So that's kind of what this new legislation provides for us. It also, the Constitutional Court's findings and the response to that, it creates a precedent for women, and it actually for the structure, in that the state mustn't necessarily let religious formality produce exclusion from constitutional protections. We are South African citizens. The constitution of our land is the supreme, and it provides for protections for all of our citizens, which should be extended to Muslim women as well. And that is a big step for substantive equality jurisprudence. So with all these reforms that we see, where does it still fail, substantive equality? We've spoken about the default matrimonial consequences. And in terms of this, it may clash with religious norms, where in practice, or the registration of civil marriages may result in a couple having a default regime as in community of property, where they don't know that they have to register an antenuptial contract. So you go to Home Affairs, you enter into a marriage, and then it's by default in community of property. You know, with regards to proving your marriage, there's still a lot of burden that remains for women in particular, where you have to produce a nikah certificate, or you must have affidavits to prove that you are married. Some of the older people don't have that piece of paper, so how do you prove that you are married? There's nothing. So there is still an administrative burden because there is no registration of Muslim marriages. You know, so that still is something that we this reform kind of is lacking, where we don't have a register. If your civil marriages, there is a register at Department of Home Affairs. And this has been to the detriment of women, Muslim women, because we've had in the past secret marriages. So because there's no registration, there's no regulation of our marriages, we had men entering into multiple marriages without the wife's knowledge. And that caused a lot of, severe disadvantage for women. Polygamy, polygyny, and regulation of multiple marriages. The law currently recognizes Muslim marriages for many purposes, but it doesn't fully resolve the issue about polygyny, as Kinsani has mentioned. Recognition of Customary Marriages Act, it does make provision for polygamous marriages where it requires a consent. It requires for the court to look at the economic consequences among multiple spouses. It looks at inheritance and children's rights. So inheritance for Muslim marriages, it now does extend to polygamous marriages. So both wives are then able to claim inheritance. But it's still, there is no legislation that governs our polygamous marriages. So it's still a little bit, there is, there's nothing for us as Muslim women. Let's see. So what the practical consequences of legislative reform is that more women can seek maintenance. They can approach the court for an equitable division of assets. They can, there's more child-focused orders in court, and that is a tangible improvement for Muslim women. Those women who, as I said, still are unable to provide documentary proof of their marriage, unfortunately, they may still be excluded from practices. So that's something that is where these reforms are still lacking. But at the end of the day, the outcome will also heavily depend on how the court interprets patrimonial claims. The court will have to balance what your Sharia expectation is versus what the constitutional values are. And that's why the results will vary, because there is no fixed framework. We're still at the mercy of the court. So how could we improve the reform so that they actually deliver on substantive equality? We can allow Muslims to register, to be flexible in the options that they choose with regards to the matrimonial property regime. And Islam allows, it actually encourages mutual consultation. So upon entering your marriage, you can have this discussion on how do you want your marriage to be regulated? Do you want it to be in community of property or out of community of property, with accrual, without accrual? And the lived experience is that couples are now in this economic climate that we are living in, both having to contribute towards your family. But upon dissolution, what is going to be a just, fair, kind, and equitable exit? So it's important for us to have that consultation at the beginning before you actually enter into this marriage, so that going forward, that you're quite clear on where you stand and how things will devolve. We need to have more community clinics. We need to have more engagement. We need to have information campaigns like this, which I think is brilliant, so that in the Muslim communities, so that the women know what their rights are and how they can access these rights. Because even last week when we went to Mitchell's Plain, people didn't know. We've got people reaching out to me on Facebook, I need assistance, I don't understand this. So we need more of this until we actually get to that piece of legislation that we are going to be happy with. We need to have specific rules and regulations that set clear rules about consent, about your economic sharing, about your children's rights when it comes to polygamous marriages. It needs to be rules, there needs to be a framework that we are guided by, so that when we are in that situation, we don't find ourselves struggling with how do we navigate this landscape. And then, as I said previously, there is no current register of Muslim marriages, so we need to monitor the data, and we need to have some mechanism where where complaints can be channeled. So published data sets, data on the registration, the divorces, have that complaints channel, and address that. I think would be vital in addressing these secret marriages that we have. So the recent Constitutional Court judgment and the Divorce Amendment Act, it does close a huge gap because it brings Muslim marriages into the legal mainstream, and it now gives women access to important civil remedies that they were not previously had access to. And that, I believe, is a major step towards substantive equality. But recognition alone is not guaranteed, doesn't guarantee equitable outcomes. So we need to implement the legislation carefully. We need to make sure that the legislation protects women's economic rights, and we need to have these community outreach programs where women are taught their rights and can actually use these rights. Insani also then asked me to speak about what effect will codifying Muslim marriages have. Does it risk eroding religious autonomy, or can it strengthen women's constitutional rights? So obviously, the whole discussion around regulation and recognition of Muslim marriages, it creates a tension between freedom of religion, cultural autonomy, and your rights in terms of the constitution, the right to equality. So while the state has taken, these steps with regards to this Divorce Amendment Act, there's still serious challenges which remain when we're looking at translating the formal recognition into substantive equality for Muslim women in particular. And like I say, codifying marriages, it's a sensitive topic between religious doctrine and constitutional oversight. Some critics argue that state regulation of Muslim marriages risks eroding religious autonomy, as the state could impose secular interpretations on religious concepts such as talaq, mahr, or polygyny. And codification may also privilege one interpretation of the Sharia over others. But there's a counter argument to that, and that is grounded in constitutionality. It's grounded on equality and, most importantly, dignity. And that the non-recognition and non-regulation of Muslim marriages has been far more harmful to women's autonomy than recognition could ever be. Women were for decades excluded from the civil remedies that were available to other spouses, and that's why codification can strengthen a woman's rights by bringing Muslim marriages within the protective ambit of South African family law without necessarily secularizing Islam. And the key here lies with preserving the religious character of Muslim marriage while ensuring that the legal consequences comply with the constitutional standards. And in terms of a Muslim marriage, we have rights and responsibilities. And those things can be aligned with our constitution. Our religion speaks about and encourages mutual consultation, justice, fairness, kindness, equity. Those are concepts which is enshrined in our Quran, which can align with constitutional values. So when we look at the recognition of customary marriages, that relates to the Black customary marriages. It doesn't make provision for Muslim marriages in particular, but we can look at it. We can look at some of the sections in that act and how it applies to our Islamic, Muslim customs. And it's important that these laws that are promulgated are implemented effectively. So whereas the RCMA, it recognized the customary marriages, there were still women who remained vulnerable because they were not aware of their rights, and the registration of customary marriages were not done very well. So that's why women in these marriages still remain vulnerable. So for Muslims, we need to be cognizant of what the little pitfalls were when you're looking at RCMA and how we can learn from those mistakes when we are looking at promulgating this new legislation around Muslim marriages. We need to, equality, you need to have substantive equality, as I've said earlier, not just the formality of it is it's easier, but how is it actually going to be enforced? How are we actually going to implement it on the ground? There needs to be clarity and consistency when we are talking about our marital regimes, because Muslim marriages, you know, it could, it could be aligned with both your Islamic contractual principles and constitutional fairness. And this is vital to prevent confusion and further equality. And as I've said, education and participation is crucial. Continue the dialogue, continue the discussions, ensure that your religious leaders, your women themselves in your communities are involved in the discussions, so that when this legislation is codified, it must be accompanied by educational campaigns and access to legal aid, ensuring that women understand and they can exercise their right. Urgent reforms that are needed, I would say a comprehensive marriage act. We still lack a piece of legislation governing all forms of marriage. And as previously earlier discussed, there will be this omnibus piece of legislation which will deal with all forms of marriages, irrespective of your religion. So civil, customary, religious marriages will all be governed by this one act. And that would be a way of closing the current gaps and avoiding the piecemeal legislation. Must also be a more simplified and low-cost procedure for registering Muslim marriages. By default, out of community of property. And what does that mean? You must have this antenuptial contract, which costs money. It must be registered in the deeds office. For a normal civil marriage, if you don't have a contract, it's with in community of property. But again, here, the couple needs to decide. They need to have that option of choosing how they want to have their marriage regulated, and it must be by mutual consultation, and they must understand the consequences of each marital regime before they enter into the marriage. Let's see what else is there. Also very critical, yes, I know my time, I've got a few minutes. Also critical is that officials who are officiating these marriages must be equipped to balance the respect for tradition with their commitment to equality within our constitutional framework. And then while codification may raise fears of state intrusion into religious life, the greater danger lies in inaction, leaving women unprotected in the name of autonomy. And the experience of customary marriages shows that recognition, if accompanied by education, clarity, and genuine equality, it can uplift rather than undermine tradition. And in closing, I'd just like to say that the challenge ahead is not to choose between faith and rights, but to weave them together, so that every woman, regardless of the form that her marriage takes, enjoys the full promise of South Africa's constitutional democracy. Thank you. Insani, I still had 4 minutes.
Distinct.
Thank you so much, Aisha, for that enriching presentation. Do we have anything online? Okay, nothing online. It's our Q and. Pardon? Oh, no one is asking me questions.
Thank you, Aisha, for an excellent and comprehensive presentation. I'm Fatima Isop. I had two questions. The one was to maybe clarify. I've heard this term used a few times this year, this notion of a secret marriage. Can you just elaborate on that? And then the second issue was, I know you indicated that with respect to the last bill, there was an issue around people not wanting the compulsory mediation. But the way divorces work now is that it's not compulsory, but in terms of the uniform rules of court, parties are strongly encouraged to actually engage in mediation to alleviate the backlog in court. So I'm not sure how that, what your understanding now is of this idea that parties should actually engage in some form of mediation before resorting to the divorce proceedings.
So thank you, Fatima, for that question. Secret marriages that I refer to is we found in the network and the women that we work with, because there's no registration of Muslim marriage, and in terms of our religion, a man is allowed to have up to 4 wives. What happens is that men get married in Cape Town, and then they go up country and they get married there, and the wife here in Cape Town doesn't know about the other wife, or and that has, and until much later it comes out. So that's the secret. When I talk about secret marriage, where the first wife or the second wife or the third wife is unaware of the other marriages, it has an effect on the family economically.
Okay, so that was my understanding, but this has happened for years.
It
Is
has
that
happened for
the
years.
wife generally finds out when the husband dies that he has a completely different family?
Yes.
So you're talking about those multiple
I'm
polygamous
talking about
unions where the husbands simply don't inform the.
that they're not informed of.
Okay, now I
And in terms
understand.
of RCMA, which regulates polygamous marriages, the court needs to be, you need to approach the court, you need to apply to the court for what's the word?
The consent, yeah.
Not the consent really. So with recognition of customary marriages, if you wish to be in a polygamous marriage, you need to submit a contract to the court in terms of section
Yes.
7.6, which would outline how distribution will go in that particular union. But till today, there is no records of this contract ever being registered or being ventilated at court. And also, the issues with, for example, with customary marriages is that men would marry in the rurals. Then they will move to Joburg. When they get to Joburg, they will enter into a civil marriage in terms of the Marriage Act. Then it's only then until death when the wife is like, I have a marriage certificate. The other wife is obviously old and elderly, doesn't have access. Then she's left vulnerable. But then the court has been very intentional about saying that you do require your first, if you want to enter in a polygamous marriage, you are required to have the first wife's consent. But also with the civil and customary marriages, the court then ends up saying that the second marriage is invalid, right?
That's right.
Because they then recognize the customary marriage. But then we can also have a conversation about what that invalidity, the impact it actually has on the second wife, right, in this actual civil marriage. Yeah, but we might actually see the same patterns post recognition.
Absolutely, because that's just the point, isn't it? That even though the Recognition of Customary Marriages Act requires registration of multiple marriages, the lived reality is it doesn't really happen. And so, what makes us think that that's going to be the case with Muslim marriages? I doubt it. Men are still going to go ahead and have those multiple marriages without complying with the registration. And you're absolutely right. The court has declared the second marriage invalid. But what are the implications for proprietary consequences, especially for that second wife? Right? If she's married in community, she's left with nothing.
Yeah. Your second question was on mediation. Yeah. I'll give it to Kinsan as well. So I firmly believe that mutual consultation on entering into a marriage will kind of alleviate all of these other issues that we have on dissolution of a marriage. If you, without having agreement as to how your marriage is going to be governed, you may still need mediation at the end of the day, but I think it could do away with that, where you have this clear-cut idea, this agreement or an Islamic contract, which is inter partes, you can be held accountable to that, and would actually assist when it comes to divorce.
And just maybe just to add on, I think I forgot to mention this as well. So with the mediation that the ulama were trying to enforce in after the 2010 bill, it was that mediation would then be binding. So that was why it was very problematic, because you can't have the mediation binding. It's like a commission of inquiry. The recommendations are not binding. And that is why they were pushing that narrative. But mediation with recognition and consultation looks very different, right? It's not about oppressing the woman or having all the power, but women will know exactly what the law says. They'll have that legal certainty. So even if they go into the mediation proceedings, they are well aware of what their rights are. So I think that is what will definitely be different.
Okay. I think I have questions actually for both your presentations. On Kensani's one, when you said that Muslim marriages are out of community of property, is there any legislation to that effect? Number one. Number two, um, marriages that are out of community of property, we have the accrual, whether the accrual system applies or not. So in the event of dissolution or death of a Muslim marriage, how do we then infer whether the accrual system applies or not? Because, I mean, it's not very clear to me. That was the one of out of community of property. And then, ma'am, sorry, I forgot your name. Aisha, you had mentioned a nikah certificate. Am I correct in assuming that's a marriage certificate?
The Department of Home Affairs, the minister, he called it a nikah certificate.
Okay.
To confirm that you have a married, but those certificates were issued under the RCMA.
Okay.
Not under the Marriages Act, under the RCMA.
Under the RCMA. So now, because in practicing, I've seen a couple of Muslim marriage certificates that were issued by the MJC.
That's
So I
different.
just want to understand their standing, or I don't know, why is the issuing of a nikah certificate in terms of the RCMA different to a marriage certificate issued by the MJC, and then not wanting either of those, or not necessarily, or preferring one issued by the DHA? I just wanted to understand.
So your nikah, your marriage in terms of nikah, there is no legislative framework which governs that, other than upon divorce, you can issue divorce summons. Your marriage certificate issued by Home Affairs would be under the RCMA. So all of the conditions and all of the remedies available under the RCMA would be applicable. I don't know if that answers.
There's an add-on. Add-on.
So the MJC is a religious body. There is no, they don't have any legal standing whereas they can enforce your rights and responsibilities in terms of your Muslim marriage. And that's why people were opting for the nikah under the RCMA, because it gave them some guidelines, some legal framework and protections. You would have to go. It would be a civil marriage. It would be a civil one, and the other one would just be married according to Muslim rights.
Can I just add on that? Historically, when Muslims married, they only had the nikah. So they go to the mosque before an imam, and the imam has a book which is generally issued by the MJC. And in that, he writes your details, the husband's details, the wife's details, the dowry or the mahar, and the witnesses. That he tears out, and you get a copy. So I have a copy of that marriage certificate. And then he returns the book to the MJC when it's full. Right? So when somebody comes to you with that little slip, that's what they got from the imam or the MJC. The state has no record of that. For all these decades, you have these imams with multiple books that they store at home or they give back to the MJC. So that's the one. And I was going to cover this in my presentation. The one you're talking about is something completely different. They then take that pink certificate and they go to the department and they then tell them to register and get an official DHA marriage certificate. That's I will cover it in my presentation after lunch. Just hold
Sorry,
the
yeah.
online
Also,
people,
Kumi,
online
we
people.
need to break for lunch. Okay, just
one
to say,
follow-up.
okay, one quick. I know there was another one. Then,
Okay.
just 5 minutes, and then we need to break for lunch.
Because Aisha had mentioned an official marriage register recognized by the government, can't those books then be given to the government to record all those Muslim marriages? Thank you.
Back to Bianca's.
Yes.
Who?
I think the young lady had her hand up.
Sorry, my question might actually take a bit long, but I'll try and be quick. With regards to codifying a Muslim marriage, I want to know how it would even work, because a Muslim marriage, there's an evidentiary burden. It's quite different with witnesses, and it's a verbal contract, it's not written down. So how do you even begin to say, yes, we recognize your marriage, but then you might go through a talak, which is a verbal thing, and then you have to prove with witnesses and all of that how to basically say, yes, it was divorce in terms of this, but I'm seeking this type of relief in a civil court. So I'm not sure
Okay.
how.
Just maybe like a quick answer. So, like recently, like this year, we've been inundated by queries from attorneys who are saying that when they file their clients' Rule 43s, to get that interim maintenance, the husband then comes to say that, no, but I gave you a talak, right? So then we say that, no, even if your husband gives you a talak, you still have a right to institute divorce proceedings. So just because you were granted the talak, it doesn't take away your right to institute divorce proceedings in terms of the Divorce Amendment Act.
But also, you can enter, there's nothing stopping you. Like I've said, when you enter, have your Islamic marriage contract, which stipulates all of the things that you are agreeing to, the terms of your, the regime of your marriage. We've got things like even in contracts that we've done where the parties agree that they were not going to live with in-laws, because that causes problems, right? So you can have in your contract any term that the couple decides and they agree to. And that's why I say mutual consultation before marriage is very important to iron out all these nitty-gritties. And that agreement becomes between the two interparty, where you can be held to account on that. This is your proof of what we had agreed, who's going to pay for what, who's going to take care of the children, whose responsibility it is to maintain, what the maintenance is going to be, what your mahar is going to be. So those contracts are actually becoming very popular.
Lawyers, there will be work for you after June 2026 when the legislation comes into effect. But we're going to continue the conversation after lunch.
Yeah. Thank you, everyone. We can break for lunch. Can I just please ask that we back at 2 o'clock? Thank you.
So does
Hi, everyone. Thank you so much for coming back. We are now in the last sessions for the day. Kicking us off will be Dr. Advocate Fatima Esop. She will be presenting to us on Beyond Recognition, Securing Rights of Muslim Women and Safeguarding Children's Best Interests.
Thank you. Yeah. Thank you for that. I have changed I'm going to speak generally to the topic, and I came a bit late, so please excuse me if I repeat some of the material that has been spoken about already. Just a bit of history about myself. My first encounter with Muslim family law was actually when I worked for the Legal Resources Center as an article clerk, and I watched the late Suraya Bosch working on the Rylands versus Idros case, and was so enamored and impressed by this very dynamic woman that after the LRC, I actually joined the Women's Legal Center. And I was of the first group who worked with Michelle O'Sullivan at the Women's Legal Center. And Michelle and I were the ones who then started the Muslim Family Law Project at the WLC, where we then got funding from the Ford Foundation and other organizations to fund all the queries at that stage. That was, I think, in 1999 or 2000, I can't recall, that we were getting from Muslim women. And in fact, Mrs. Daniels, in the Daniels versus Idros case, was my client. And so eventually when I went to the bar, my pupil master, Andrew Breitenbach, was one of the advocates who went to argue that matter in the SCA at the time. And I ended up going with him to the SCA in the Daniels matter. And so it's been a very long journey for me with Muslim family law. In fact, at the WLC, I was part of the group that did submissions there. And over the years, as Fatima indicated, you are told that Islamic law or Muslim family law is God-given law and that there's no way you can change it. It's inflexible, it's rigid. And so for me, I always thought, but Islam is about justice and equality and equity. Can this actually be the case? And so a few years ago, I think it was about 13 years ago, I decided to go and do a degree in Islamic studies myself. And that's when I discovered all these wonderful Islamic law subjects, like the principles of Islamic jurisprudence, which basically sets out how the substantive laws are actually derived. And actually, what I then discovered was that Islamic law was actually a vast area of law, that it was flexible, that it was open to interpretations, and that there was different ways about understanding and interpreting the text, the main text, which is the Quran and the Sunnah, and that in fact there were far more gender sensitive interpretations and ways of understanding these primary texts. So that for me was a real eye-opener. And I still continue with my work in Muslim family law because I'm now part of the Muslim Family Law Hub, and I'll tell you a bit more about that at the end. But before actually speaking about some of the issues, I wanted to highlight and I'm not sure if this has been done before, but I know that South African law is super confusing insofar as the different systems of law are concerned. So what we all know is we have the Marriage Act, right? So that's the Marriage Act in the gray, and that covers heterosexual, monogamous marriages. It doesn't recognize polygamy. And in terms of the Matrimonial Property Act, you can either be in community of property by default, out of community, without accrual, or out of community with accrual. And I know I might be speaking to the converted, but bear with me. Then you have the next one was the Recognition of Customary Marriages Act. And that was then recognizing monogamous and polygamous, but African unions, those who adhere to African customary law. Then we then had the Civil Unions Act that was passed, which recognizes same-sex unions. And still at this stage, we don't have an act which recognizes Muslim marriages and the consequences that flow from Muslim marriages, or the consequences that flow from Muslim divorces. But what we do have is Muslim marriages that are concluded by nikah only. So I got married in a mosque. They issued me a marriage certificate, and that little pink slip is all I have to prove that I'm married. The state has no recognition of that. That normally, and in a Muslim marriage, the estates are usually separate. It's different to out of community of property because at least in out of community of property, there's a mutual duty of support. It's not the case with Muslim marriages. In a Muslim marriage, the husband is solely responsible for the maintenance of the wife and the children. It's called nafaka, right? So throughout his marriage, he has to maintain. So it's slightly different to out of community, where the parties share a duty of support. And in South African law, Muslim couples, historically, they don't do contract. They go to the mosque, the imam sits there, the couple sits before the imam, they agree, the couple before the time agrees on a dowry or a mahar. It's different to Labola because the mahar goes directly to the girl, not the girl's family. It becomes hers, she owns it. And it could be anything from a symbolic amount of, in the past, our mothers asked for a 50 rand to a Kruger rand. And women are starting to ask for a bit more, but generally speaking, the custom is that women don't necessarily ask for a big amount and they don't necessarily ask for a deferred amount, right? So mahar could be a really excellent form of financial security, but women don't necessarily ask that. Couples also generally don't have contracts. Yes, we're encouraging young people to do it, but they don't generally do that. We also encourage, my son got married 2 years ago, I had him sign an anti-nuptial contract. That is the ideal, that you sign an anti-nuptial contract, in my opinion, out of community with accrual, right? So that is what I think couples should be doing. Whether they actually do so, that's another story, and that's an area for research that somebody can do. In South African divorce, as we know, you have a civil divorce, right? You have civil marriage, you have the Divorce Act, and you go to a South African court, the regional court or the high court. If it's in community, your estate gets divided 50-50 unless there's forfeiture. Out of community, up until recently, each party retained his or own property, but we now know that the Constitutional Court has handed down judgments allowing women, even if it was out of community without accrual, to claim. And then, of course, there's ANC with accrual. And then your divorce can either be opposed or unopposed. In Muslim marriages, because they were not recognized, the husband generally in Islamic law has the unilateral right to give a talaq. Right? And that, of course, that has its own challenges and limitations because there's no need for him to have witnesses. There's no need for him to write it out. He doesn't even need a reason. So you can quite easily, as the previous questioner said, there are lots of disputes of fact that can arise. Right? She can say, no, but you did give. He can say, no, but I didn't mean it, etc., etc. Also, when he gives the talaq, he has the right of conciliation. Reconciliation in the waiting period referred to an idda, right? And he has a maximum of 3 talaqs, after which the marriage ends. Now, if he refuses to give a talaq, which very often happens, she has to apply for what you call a fasakh, which is basically an annulment granted by a Sharia court. Now, you might ask, what are these Sharia courts? Sharia courts are housed by ulama bodies all over the country where they run these courts, and women come to them applying to exit the marriage because the husband refuses to give a talaq, and the Sharia court then has to hear her hearing about this fasakh application, and then the grounds differ depending on the matter, and the qadi of the Sharia court will then grant the divorce. Very important to remember is these ulama bodies and these Sharia courts have no enforcement powers, right? They can tell the husband, at most after divorce, a husband is required to pay for the 3 months waiting period maintenance. After that, if he's not required to pay any maintenance in terms of Islamic law. If the property is registered in his name, then there's nothing she can do about it. And even if that qadi of the Sharia court says, you have to be fair to her, she's lived with you for 20 years, looked after your children, looked after your home, give her half of the property, it counts for nothing unless they have no legal enforcement powers. It's basically through moral persuasion. And as we know, at that point of a marriage or divorce, there's no way you're going to get the husband to persuade the husband to grant the woman rights to his property or maintenance. So even though we had these Sharia courts, no enforcement powers. What about inheritance? Well, in terms of South African inheritance, as you know, if you don't have a will, your estate will be distributed according to the Interstate Succession Act. And the main is, if you're married and you died, is your spouse and your children, right? Then we have the recognition, the reform of Customary Law of Succession Act, and that act basically came out, was enforced after B to do away with the rules of primogeniture in African customary law. And now essentially what the reform of Customary Law of Succession Act does is it replaces customary law with very similar law distributions like the interstate common law. So it's also the wife and the children. But the court has done away with the rule of primogeniture. What happens, and then of course, if you do have a will, and this is what most Muslims do, is they include Islamic inheritance in the will. And as we know, the Wills Act regulates the testate succession. We have complete freedom of testation in South Africa, so you can give your whole estate to your cat if you so choose. But of course, your spouse has a right to claim in terms of the Maintenance of Surviving Spouse Act, and your dependents have a right to claim as well. So what Muslims do is they have this will called an Islamic will, where they incorporate Islamic law into the will, and they say, when I die, my estate must be distributed according to Islamic law, and the ulama body must decide on my death who my heirs are, Islamic law heirs are, and they must issue a distribution certificate to that effect. Right? So what does that mean? Is that when you put that in your will and you die, I've seen it at the MJC offices because I've done ethnographical research there. All the attorneys send these requests to the MJC offices, and they issue a little yellow slip, which is a distribution certificate, which sets out the wife is entitled to 1/8, the sons are entitled to double the share of the daughters, etc., etc. So that's how it works in Islamic inheritance. And the ulama body obviously plays a huge role in that sphere because it depends on their interpretation of Islamic inheritance law that they will then determine who gets to be the Islamic law heirs. And so this brings me to the issue of the ulama bodies. So basically, they are non-state theological bodies. They are not state-funded. They are all NPOs. They raise their own funding within the community. They run the Sharia courts, which adjudicate on divorces. They draft themselves for a nominal fee Islamic wills. I think it's 300 Rand if you want a will, but it's like a pro forma will that they draft, which the one where I explained where they incorporate Islamic law, and they issue these distribution certificates that the master of the High Court accepts as the final word on who the Islamic law heirs are. And then they also do various other matters like issue halal certificates, etc., etc. There are different Sharia councils or ulama councils in South Africa. In Cape Town, the three main ones are the MJC, I'm sure you've heard about them. They're in Athlone, the Muslim Assembly, which is in Newfields, and Shura al-Islam, which is in Hanover Park. These are the official ulama bodies in Cape Town. There are more, and they also issue fasakh, they also hear fasakh applications and issue fasakh certificates. Unfortunately, they are not necessarily recognized by these three main ulama bodies who have an agreement between the three of them that they will refer, that they have a system going where, for instance, they don't, for instance, allow forum shopping. So if a woman has applied for a fasakh at the MJC, then she's not going to be able to go to another body like the Muslim Assembly because they have an agreement between them that you can't forum shop. Right? And so there are other bodies, but they are not necessarily recognized. What are the limitations of these ulama bodies? Well, first of all, they're male-dominated. As Fatima indicated, you will be very lucky to find that on the main bodies, that there are, or even in the Sharia court, that there are women who are playing a very active role. There are women in the ulama bodies, but they play the roles of the counselors. So if you're applying for a fasakh, if you have a client whose husband refuses to give her talaq, and then you tell her, go to the ulama body to get your fasakh first, she first has to go for counseling. There are people who volunteer as counselors at these bodies, or some of them are paid. And after 2 or 3 sessions, then the counselor will refer her matter to the Sharia court. And the MJC sits every Thursday listening to fasakh applications. And generally, it's the qadi is a male. I call him the clerk of the court, is also a male. His sidekick is also a male. And they will then they will hear your matter. And you can imagine how disorientating it can be for many women. They come into the court, they shake their hand, with the husband shakes their hand with the qadi. Of course, the woman doesn't. And I say, of course, because the qadi won't shake her hand. And then, of course, they listen to the hearing and they will then grant the fasakh or not. I usually tell women the grounds that qadis will generally grant you a fasa is if you say your husband can't maintain you. If you say he's emotionally abusing me and he's a narcissist, you're going to really struggle, right, to get that fasa. So just keep it simple. I've observed a case where a woman had medical records of being physically abused, and she came to the court and she had an interdict, but the husband was there and he swore under oath that he didn't do any of the things that she said, and they wouldn't grant her the fasakh, right? Because the evidentiary rules of Islamic law are very different. And so, and of course, this is also an issue, and it's something that we as the Hub have been asking of these Sharia bodies. Tell us what your processes are. What are the grounds that a woman can get a fasakh? Because it's not clear to us. What is the process a woman has to undergo? What are the laws of evidence you are going to apply in that Sharia court? None of those are necessary, clear to the litigant, which comes before that Sharia court. Okay, and then also, of course, within the community, there's something called a talaq tafweed, right? Where in the upfront, as Aisha said, you can include various provisions in your contract. And one of those provisions you can include is for your husband to delegate his right of talaq to you. The ulama bodies don't encourage women to do this. Women are not educated about it. I teach Islamic divorce. My students were shocked when they heard that there's something called a talaq tafweed, because it's not something, information that is disseminated widely within the community. And of course, like I said, there are not clear grounds on what you can get a fasakh on. And of course, even the grounds that are there, they are restrictive. And then also there's different forms of Islamic divorce. There's the talaq, there's the fasakh, which is the main two divorces used in South Africa. But there's also something called the khula, right? Where the woman can obtain a dissolution of marriage for return on the condition that you compensates the husband, either returning her dowry. But once again, the ulama don't encourage this form of divorce, and it's not very commonly practiced within South Africa. And then, as I said earlier, they have very limited enforcement powers. So, as I explained, we still only have the nikah, Muslim marriages, but fortunately, we had all these various litigation thanks to the WLC. And of course, the most groundbreaking case was the 2022 case where the WLC got the court to declare that all Muslim marriages were now regarded as valid and told the state to go off and to enact legislation, right? And so the Concord ordered the state to do it. But as we know, 2 years passed, no legislation in the making. And if you ask me, quite frankly, I never think there's going to be legislation that's going to recognize the consequences. Call me a pessimist, but I think 30 years of trying has shown me that I don't think that's ever going to happen. But what did happen, right, is that the Department of Home Affairs issued a really strange circular stipulate. So this is after the Concord case. 3 things happened. The Department of Home Affairs issued a circular and stipulating that all marriage registered marriage officers were required to register Muslim marriages in terms of the recognition of Custom Marriages Act. Why was this confusing? Well, for the simple reason that most Muslim couples don't conduct their lives according to African customary law. And the consequences of a Muslim marriage is very different to African customary law. So in African customary law, you have labola, which goes to the family, and it's a long process. It's not a once-off payment. And those who are familiar with African customary law will know this. In Islamic law, there's mahar. The boy pays the girl directly and it remains her property. Similarly, in African customary law, there's no limit on polygyny. In Islamic law, there's limits on 4, but also other requirements, equitable and just requirements the husband has to meet. So as a consequence of this, that Muslim law is very different to African customary law. It's no surprise that many couples didn't do that. And in fact, the ulama bodies told couples, do not register your marriage as under the Recognition of Customary Marriages Act. For obvious reasons, because that's not what the Concord decision said. The Concord decision said, go off and draft legislation. Right, so that was the one thing that happened. The second thing that happened was you had this Al-Jamia or Al-Jama'ah parties bill, and that was, I think it was last year or earlier this year, when our Home Affairs made a big fuss about this whole couples can now go and get a Muslim marriage certificate. Right? What does this actually mean? It means you take your pink little certificate from the imam, you go to the Home Affairs office, and they give you an official Department of Home Affairs Muslim marriage certificate. Right? What it doesn't mean is that you got married in terms of a registered marriage. Right? There's a difference. All that shows is now you got a marriage, that you're on the system as a Muslim marriage. It also allows you to travel because some people need proof that they are spouses when they travel. So it's proof that you're married in terms of Muslim law. And your marriage is still separate estates. Unless, of course, you took the further step and you had your marriage registered as a civil marriage. Then you are either married in community or out of community without a accrual or out. And for the latter two, you need an ANC. Right? So this caused even more confusion. I don't even know what the department was doing when they did this particular, or Al Jamaa party was doing when they tried this move, because it just confused people even more. And then, of course, the most far-reaching was the Divorce Amendment Act that was passed last year. And this, of course, is the most far-reaching. Why? Because as I explained up front, in a Muslim marriage, your estates are separate. What happens historically since the time of Daniels, when I was working at WLC, is, and especially I think Aisha was saying a lot of, or I think somebody else said a lot of women who come to the WLC with problems with their Muslim marriages are older women. They never registered property in their name. They worked all their life in their marriage, and now they are stranded because at the end of their talaq or fasakh, all they get is 3 months iddah, nothing more. They don't get any maintenance beyond, no lifetime maintenance, no redistribution of assets. They are left financially stranded. And so this is what this act now seeks to address, is that it says that if you're married by nikah only, you will be covered by the Divorce Act when you divorce, which is wonderful. Because what does this mean? It means actually that she can now, it's been amended to include Muslim marriages. You can now have the court order any issues pertaining, for instance, to minor children. Now, when you are going through a divorce, you can now you can have your matter, your children have automatic right to a report from the Family Advocate's Office, which wasn't the case before. It wasn't automatic. Even more, and more importantly, you now have an amendment of Section 7 of the Divorce Act, which allows for a redistribution of assets from one party to another. This is the biggest gain of the Divorce Amendment Act, is that Muslim women can now say, yes, I contributed non-tangibly to the growth of this marriage and the growth of this estate, and I should have a redistribution of his assets. Right? So this is a big win for women, because now the courts will take into account the non-financial contributions of either spouse, yes, but as we know, it's generally the woman who's made the non-financial contributions. And where he has had more than one wife, the court will take this into account as well, right? Because polygamy is still definitely practiced. And like in a civil marriage, the court will also grant a forfeiture of benefits. Then also, who does the act apply to? This is very interesting, right? Because the act applies, in Section 6, it says, including a marriage which was terminated or dissolved in accordance with the tenets of Islam, or legal proceedings for the dissolution of the Muslim marriage in terms of the Divorce Act have been instituted but not yet finalized, and which subsist on the 15th of December 2014. This has caused immense confusion in terms of application. Sub A applies to a small and you can't use this particular act. You would have to have been married by 15th of December 2014. And I know this because I was asked for advice on a matter where this husband has actually claimed, where she's now claiming, in terms of the Divorce Amendment Act, and he said, actually, I divorced you in September 2014. And of course, he's doing that to avoid Section 6B, right? And of course, the issue is in such dispute because a husband can say, I talaq you, and he can afterwards say, I didn't talaq you. There's no written proof, there's nothing, because you don't need it in terms of the understanding of Islamic law in South Africa, right? So this is who the act actually applies to. It applies retrospectively, but you had to have been married according to Islamic law after the 14th of December 2014. What about Rule 43? As you said earlier, this has now happened. Men are saying, well, actually, I don't have to, women are bringing Rule 40, they're instituting action in terms of the DAA, and then they're doing the interim Rule 43 maintenance or contribution towards their legal costs. And then what are the husbands coming back with? But I talaked you, we're not married. Right? And so I don't have to pay you interim maintenance. I don't have to contribute to your cost order. This is the case of Aesop versus Hafaji, where the husband says that it didn't apply because there was no valid marriage after the talaq, and therefore the wife was not a spouse. Also, we have another case, Abdullah versus Alpa. The court held that the spouse includes not only person admitted to be a spouse, but also one who alleges that he or she is a spouse, even when the allegation is denied by the other part. Another win for Muslim women is that the court's not interested in men coming to court and saying, actually, I talaqed you, you're not entitled. Because as you know, at the Rule 43, that's not, whether you think you're married or not, that's not of relevance. She's claiming she's married and she's entitled, and so the courts have accepted that. Right? And I think this particular case also, the court gave the HA versus NA 225, where the court says, I disagree with the respondent's counsel submission that the applicant does not meet the definition of the term spouse in Rule 43, and this court subsequently does not have the necessary jurisdiction to hear the application. I'm in full agreement with the view in the Saperio case. He explained that Rule 53 was merely designed to provide a streamlined and inexpensive procedure for securing interim relief. So the courts have actually been coming to the help of women, right? Then also to remember that the Divorce Amendment Act section, the Divorce Act it's important to remember that just because she's getting the divorce, in terms of the Divorce Amendment Act, doesn't mean that she still mustn't get her Islamic divorce, right? Because we are saddled still, and I don't know why anybody has not challenged this, we are still saddled with Section 5A of the Divorce Act, right? Which means the court will refuse to grant a civil divorce if either the spouses are unable to remarry. And this initially applied to Jewish marriages, when husbands also refused to divorce their Jewish wives through the get process. The courts were reluctant to grant the civil divorce because even if they granted it, that woman couldn't remarry because the husband was, it's what you call a limping marriage. And this is what happens in Islamic law as well. Even if she gets the divorce in terms of Divorce Amendment Act, that husband is going to say, I don't recognize it, the ulama doesn't recognize it, and the whole community doesn't recognize it. In our eyes, you're still married and you can't remarry. Right? So what we encourage lawyers to do in your pleadings is to also ask that the husband issues the talaq. Right? Otherwise, she's going to be stuck in what you call a limping marriage. So remember that 5A still applies. What has been the response by the ulama bodies? Well, in the north of South Africa, the Gauteng area, I know from people from first-hand experience that women have told me, ulama bodies have strongly discouraged women from pursuing relief in terms of the Divorce Amendment Act. They are telling women it's against the Sharia. They are excommunicating women who do pursue this remedy. They say that you cannot go to a non-Muslim court to dissolve your marriage, and that in fact you're only entitled to maintenance during your iddah. My response to that is, if civil courts are good enough for your labor matters and your tax matters, then they're most definitely good enough for you to institute action in terms of the Divorce Amendment Act. Because you know what, very interestingly, 2 years ago, the president of the MJC took the MJC to the labor court because for unfair dismissal. So if it's okay for you to access the labor court or any other, or the civil court for your debts or for everything else, then don't tell women it's not okay to access the courts for remedy, because the reality is she's not entitled, she can't get any remedy through the ulama bodies because they have no enforcement powers. And so I conclude by saying that as a minority Muslim community in a constitutional democracy, we're constantly finding ourselves navigating these two systems of law. We're between Islamic law and what the ulama tell us, and then We have the South African law, which is trying to help us, but as Aisha indicated, not necessarily going far enough, because we have to remember that there's still no legislation recognizing Muslim marriages and the consequences of that marriages, whether it be mahr, nafaka, etc., all the issues around divorce. Whether we want that, that's another story and it's another symposium, but I'm just making that point. And to understand that actually women are exercising agency, they forum shop, and they, despite what ulama are telling them, they are seeking remedies through the Divorce Amendment Act, which I think is a very positive step. And what we need is more women to be aware of it, but also more lawyers to assist women, because many times these women can't afford legal representation, right? They are not able to take, because they are generally the one in the weaker financial position, and we don't have necessarily enough lawyers who are taking these matters on a pro bono basis for women who find themselves in this particular situation. And so I think then to just conclude that, to say that we at the Hub, the Muslim Family Hub, we're seeking to educate and advocate for more Muslim, equitable Muslim family law outcomes. And I thought I'd just send, the Hub was started last year, and we have one of our main tools is our website. And our website has 3 doors. It has a marriage door, a divorce door, an inheritance door. And under each door, you will find a number of things. You'll find the Islamic law on divorce and talaq and fas. You'll find what the South African law has to say. You'll find a checklist of things that you need to tick off if you want to consider divorce under both systems. And then you'll find resources. We find that generally women need legal assistance. So you'll have legal bodies and organizations. There's pro bono. Marcy, I was chatting to Marcy, FAMSA, UCT Law Clinic. We also have some law firms. We have application forms like protection orders that if you need a domestic violence interdict, these are the forms you can download, the maintenance forms you can download. We also have mental health care providers, because we recognize when women are going through a divorce, it's a real struggle, it's very traumatic. So we've uploaded various mental health care providers that women can access, private and generally, like the counseling hub, FAMSA, etc. And then we have various shelters that women can access. And lastly, we also recognize that women need financial assistance on divorce. And the only organization we could put down there, sadly, is SANZAF, because they will assist women in paying their rent, arrears rent, or paying for the legal fees if it's in arrears, etc. So that is, you can have a look at our website. We have various, it's under each particular door, marriage, divorce, and inheritance. Because I was just telling Marcy, is that what we find is that people might know the Islamic rights, Islamic law rights, but they don't know their rights under South African law. Practitioners might know South African law, but they don't know what's happening in Islamic law. And so our aim is to try and educate people on both systems of law, so that individuals can actually navigate all these areas of your life with autonomy and agency in a very kind of educated and informed way. Thank you. I don't know if I'm over time. Here we go.
Thank you so much, Dr. Advocate Esop, for that enriching presentation. I just wanted to check, do we have any questions online? And do we have questions in the house?
Thank you very much for your presentation. I think I have maybe a religious question. In the event, I'm not a radical, okay? In the event, say now I am married by Muslim rights and I decide to now use the Divorce Amendment Act to divorce my husband. And then obviously then they would assume or say that it doesn't apply in terms of Islamic rights because he did not talak me. What then happens if I decide to abandon the Islamic faith totally and say, well, now I'm atheist or I'm Buddhist, I'm no longer a Muslim?
If you abandon your faith, your marriage is automatically then dissolved. Yeah, so apostasy is considered quite seriously in Islamic law. So if one of the parties abandons their faith, then their marriage is actually terminated. But she doesn't have to go through that lens. She can apply for a fasakh and she can forum shop till she finds an organization, or she can try and get a khula. to get out of the marriage. So talaq is not the only form of Islamic divorce, right? There's also the fasakh, like I indicated, and there's khula, which even though it's not customary practice in South Africa, it is a legitimate form of exiting a Muslim marriage.
I can just add to that. So this practice, I think it was the early 20th century in India. Women were having such a difficult time coming out of marriages that apostasy was a way women were leaving marriages, Muslim marriages. That it was people were leaving Islam to come out of the marriage, to denounce Islam for a moment, and then they would re-embrace Islam. But they would denounce it as a means of exiting marriage. Well, everybody's going to welcome you back if you come back, right? And especially if we know that it's a mechanism you're using to release yourself from a problematic marriage. So you're thinking of a mechanism that was used. It was used, and it was used to such an extent that it prompted law reform in India. Yeah.
So you mentioned, you spoke about the ulama bodies, and it's mostly male dominated, and we know that, of course, it's sheikhs and men have certain authority. But is there a way to form a woman-led body or ulama body that can also, you know, see to these issues, and women can approach them, and it's more of a fair process as opposed to just siding with a man at whichever, you know, the famous ulama body that is very problematic towards women.
Hmm. So I have to, there are certain disclaimers I have to make. First of all these ulama bodies don't necessarily always side with men, but it is more of a struggle for women in certain instances, especially like I say, if you can prove that your husband doesn't nafaka you, then you're going to get out easily. But if you're saying he's a narcissist, you're going to find it far harder, right? It's not like in South African law where you have irretrievable breakdown. And then in terms of gender representativity, I mean, this is something that, I mean, I've written on it, that the need for gender representativity in ulama bodies, because it's not like we lack female scholars to sit on these bodies. We have enough women. So Fatima was saying there aren't institutions, but actually there are institutions generating, like the IPSA, Islamic Peace College, they're generating all these graduates who have done Islamic law of marriage, have done Islamic law of divorce, and they can easily sit in these courts, and it's not very complicated listening to an Islamic divorce matter, but they're not being brought on board into these structures. And so yes, your question is, do we have a separate body? Yes, of course we can. We could have women creating their own body, but the issue is as even though these bodies are not necessarily administering justice in the way we think is as fair and as just as it could be, they have the buy-in of the community. These bodies, and that's why we were very, very determined with the hub not to alienate these bodies, because the fact of the matter is that they have the buy-in of the community, the community defers to them, and if we want change, it's not going to come from a position of us telling women this is what you need and what you need to do. It's women themselves who have to agitate and advocate for that change. Women who have experienced the difficulties in these ulama bodies to say we want the change. I've written about it, but that means nothing. What matters is that if you have public advocacy and people educating themselves and saying, actually, women can sit on these bodies. The Hanafi madhab allows a woman to be a judge. Why are you not having women? And that is what's needed.
So what you're saying, instead of creating a separate body, it's to allow women into head positions in these existing ulama bodies.
I'm not saying they're mutually exclusive. I don't think there's. I think there might be room for actually having bodies which are what's named by women, run by women. But I don't think they should be mutual. We should try and get ourselves onto existing bodies, even though that's really proving to be very difficult. And then also, I don't say that that's not an option. Whether it will have the buy-in of the community, that's a different story.
The last thing I just want to touch on is, you said, you know, these ulama bodies will give a woman a fasach easier if she can prove that the husband is not maintaining or nafacating her. I was in that position, and none of those the main ulama bodies assisted me with that. I had to go to a mufti from a different Islamic society, and it's yeah, it's not
I know. You
difficult.
Very difficult. And you're not the first person. And we've spoken to so many women who just find it so difficult. In fact, I did ethnographical research in the Sharia court of one of the main bodies, and I saw the struggle that women encounter. So it's easier, it's not guaranteed if you say nafaka. If you say emotional abuse, there was one woman I observed, she was financially independent. She just wanted out of the marriage because she said he was a narcissist. Then they kept saying to her, so he doesn't nafaka you. She said, no, I'm not interested in his money. I want out because I don't love him anymore and he's a narcissist. But they struggle to get their head around that. And then, if they were advocating khul as a form of divorce, she should have been able to access the khul, right? And the only way, I know I shouldn't have done this, but I descended into the arena in my research, and I asked the Qadi, don't you consider khul as a form of divorce? And Vrachtiva, the next one, he did a khul, right? And the parties didn't even know what that was about because it's not something that's very commonly understood in South Africa.
It's not, and I also didn't know about the hula, but is it, maybe this is not the right way to ask it, but is it kind of more that the ulama or certain, I don't want to generalize, but it's not preferred for the woman to, I'm stepping on toes, to have a choice. It's more that they give the man the choice because that's how they interpret Sharia law.
Yes, of course. It means giving more power to women, and why would they want that?
Yeah, which is, how do we get rid of it? How do we change that narrative?
In fact, I was on the radio a few weeks back with one of the counselors at the MJC, and she says, Fatima, more and more women are asking about khula because they read it on the internet. So women are slowly but surely becoming more and more educated.
Just wanted to expand on the various organizations, and then in answer to her that in practice, we found that dealing with the MJC is problematic. They're not very kind towards our women. So in practice, I don't send my clients to the MJC. I send them to Shura. And I'm sorry if I step on anybody's toes for that, but that's the lived reality of women.
Just to say that is also my experience, and that's what I do as well. So of those three bodies that I mentioned, this particular body, Shura, has the closest to what you call due process. And in fact, they have a woman, but the problem is they only sit once a month on a Saturday. And I think they have a female lawyer that sits on their panel when they consider that fasakh application. And in fact, they have told me, I've sat in meetings with them where they have told me that the MJC themselves refer their imams to Shura for their divorces because they are known as the ones who are most sound. And even them, I've told them, can't you provide the public on your website with a step 1, step 2, step 3 kind of procedure that so people know, like you have in the Uniform Rules of Court, right? Or you have in the Divorce Act, it's irretrievable breakdown, mental insanity, and I don't know what the third ground is. But you don't have those clear grounds. And in Islamic law, you have different schools. And this is to your point on codification, which I think is going to make it a bit harder. You're right. Precisely because in Islamic law, there's actually no codified law, right? There's the Quran and there's multiple interpretations on verses in the Quran. And so Islamic law is juris-based law, right? And so all we're telling them is provide the public what, in terms of the Shafi, which is the dominant school, these are the grounds. But in terms of the Maliki school, you can get divorced if it's emotional abuse. You can get divorced for any of those. They're far more broader grounds. Tell the public these are the grounds, women, that you have to meet, or criteria you have to meet to obtain your fasakh. And these are the processes, and these are the rules of evidence. There's nothing like that.
Sorry, I just want to say on that, I also don't advise anyone. Like I stay away from the MJC, but I went to the Shura Council also, and whether it's MJC, Shura Council, men. Again, I'm not generalizing, but from what I've heard and seen, they just don't pitch, and then there's no consequences, and the woman keeps suffering. So
That's a very important point, and that's what I observed in my research as well. Is they send the man a letter. He must come to the counselling. He doesn't come. Now, if he doesn't come to the counselling, the matter doesn't get referred to the court. And so it can drag on literally for years because the men refuse. Even in the past, they used to send the man a registered letter to say, okay, we've now tried over 2 years to get hold of you. You're not coming forward. We're setting the matter down for the court. And then he doesn't come to the court on the day either. When I observed it, the court will grant it in the absence of the husband, which I've also found very interesting. But that is definitely a problem, is that men don't turn and then the matter just gets delayed.
I picked up a common thread with all the speakers, and that is the issue around the Islamic bodies. Not only in terms of the difficulty that women experience, but also the fact that what they enforce is not actually enforceable. Men go against it. And so with this law and the recognition of Muslim marriages, it's left me thinking like we need to inform them, because it's as a result of what they're doing and how they're treating women that we have to reach this point. And so how do we do that? Or do we do that as a collective to go, this is actually what's happening? And it's going to override them. And therefore, and it goes further to when we put this campaign together to inform people about their rights, to inform Muslim women of their rights. We used our online media platforms. We used these legal symposiums, community workshops. And when it came to me approaching radios, especially community radio stations, which is so targeted to the Muslim community, one radio station said to me, this is going to upset their listeners because it goes against Islamic law. Even when I created the context of why we've reached this point in law, they wouldn't offer us the airtime.
Yeah, you're absolutely right. It's about educating the ulama as well. And last year, shortly after we launched the hub, we had a webinar on the Divorce Amendment Act where we specifically invited all three ulama bodies and other ulama. That was very well attended by all our lawyers. Not one single ulama attended. Right? We're the ones who we're trying to educate because this is the ideal. You're giving people advice, but here's this new act, and this is actually what it means for women. And as you said, Cape Town is considered so-called liberal. Up north, they're just telling women, you're not allowed to do it. And you know what happens is up north, because they're in the Hanafi madhab, they don't necessarily recognize grounds for an annulment or a fasakh unless the man is impotent, sterile, crazy, or some really restrictive grounds. So you know what happens is very often those women will come down, they'll fly to Cape Town and they'll go to Shura to apply for their fasakh because they can't get out of their marriages in Johannesburg. It's far, it's like a different country up there. Right? It also depends on where you are in Gauteng. I had a lawyer tell me it depends on which side, literally which side of the line you are, the train line. If you're in the Nuclei, Bosman, so-called colored Malay area, then there's a more liberal understanding of your Islam, whereas the minute you move to the, sorry for the terminology, but the Indian Hanafi stronghold, then you're buggered. You're stuck in that marriage.
Yes, Prof, you may go ahead.
I just wanted to add, I think what everybody's also talking about is this difficult fit between two systems of law, right? You've got one very particular system of civil law, you've got a historical system of Islamic law. And trying to fit these things together is obviously our biggest challenge. I think, so this idea of telling the ulama, they know. We don't have to tell them. In fact, they created the situation, and this is the situation that they want. What is wanted? What is wanted is a system of law which is governed by religious scholars. It's what they want. And what feminist reform of Islamic law is resisting is just that. Because what our argument is that We'd rather be governed in a legal system that is state recognized than have this, this alternative system. The question is how we see this alternative system. So I'm saying this, Fatima, because I think it's important the narrative we create around these bodies. For us to call them Sharia courts, they are not courts in South Africa. They have no legal standing as a court. So even if they're calling themselves courts, I resist calling them courts. Aisha just corrected me. I call them religious authority. Aisha said they are religious bodies. Because the fact of the matter is that anybody can perform a nikah. I today can perform a nikah between two people. It's considered a valid nikah, whether or not I have any standing. I just need to make sure there are witnesses, there's a mahar, there's a ask and the answer. That's a valid nikah. They have taken it upon themselves that only they can perform valid nikahs, and the state has come to recognize that. I, as a wife, can exit my marriage by issuing a khula. I don't need an MJC to confirm it, or anybody, because that's the nature of Islamic law. Authority sits inside the individual. Right? Unless you're in an Islamic state where authority sits in the leader of the state, and then it's passed down to the courts. And I think it's important for us to understand this, because through this process of recognition of Muslim marriage in South Africa, we have what I think it's almost like the clergy making in Islamic law. Islam doesn't have a clergy, but through the adjudication of Muslim marriage, we've now made a clergy. Clergy which calls itself, they constitute themselves in courts. They're now calling themselves qadi. A qadi is acknowledged by a state, but none of these people are qadis. They are muftis, because they've got a mufti qualification. So I think this narrative is really important. If we start creating this and recognize this as a parallel legal system that's happening in our country and give it that kind of recognition, then they sit in that position. But if we constantly speak about them as religious bodies, self-designated, self-authorized, and yes, the option of creating, remember when people don't invite you to their table, what's the classic feminist response? Make our own tables. And so yes, create your own group of women scholars who are doing the same thing, who can do a nikah, who can tell you that your khula is right, that your talaq is right, and that is an option. I don't think we should rule that out. I think that's how we challenge and we keep the systems open as well.
Completely. That's why I say they're not mutually exclusive. And I appreciate what you're saying, Fatima, but I'm like the WLC, I believe in lived realities, right? And the lived reality is that South Africa is what you have what you call a deep pluralism, a deep legal pluralism. So you have the official law, the state law, you have official African customary law, but you also have lived African customary law, right? There's the law on the books, what the courts have decided. Does that happen in the lived reality? No, we know that that doesn't happen, right? Even though the courts have ruled out primogeniture, does it mean that it doesn't happen within African customary families? Of course it happens, right? Similarly, like we're saying, the Recognition of Customary Marriages Act, beautiful act, saying you must come and register your second. Does it happen? No. Right? So similarly, with Muslim marriages and Muslim divorces, yes, of course, it's not state recognized, but is it operating? Do they call themselves as courts and qadis? Absolutely. Are they recognized by the community in that regard? Absolutely. And yes, you're right. Like, you can issue a khul, right, to get out. But I was relating to my students yesterday, the story that you told us, Fatima, of a woman who, I think it was you or somebody, issued her a khul. She wanted out of a divorce. Her husband refused to give her a divorce, a talaq. She then got the khul to get out. I don't know if she paid him compensation. I remember the story from Fatima. Yes, but then her marriage wasn't, her family didn't recognize that khul. Years later, when she wants to remarry husband number 2, who then comes to ask for her hand in marriage, her father says, but she's not divorced. Why? Because he didn't recognize that khul, right? So, of course, khul is valid, we know, classical, but the lived reality is that community and family doesn't recognize it. And so what did she have to do? She had to go and ask husband number 1 for the talaq anyway, right? And get the talaq before she could marry husband number 2. So that's the difference between the theory of law, which is wonderful. In theory, Islamic law is just and equitable, absolutely. The lived reality. And it's no different to South African law. We have the most amazing constitution, isn't it? We have the Domestic Violence Act, isn't it? We have amazing laws. Enforcement, we're pathetic. We have the highest level of domestic violence, the highest level of family-based violence. We have the most amazing Maintenance Act. Tell me one woman who has an easy time in the maintenance court. One woman who has an easy time obtaining the maintenance from that husband who's dodging it at every opportunity. So it's not the fact of the laws. The laws are amazing. Where are we falling short? Enforcement. That's the problem.
Can I ask a question? Won't it be easier for all people, regardless of religion, to be encouraged to rather comply with to rather enter into a civil marriage? From the perspective of an attorney who does family law, for example, I don't know about the rest, but this is a lot of information, and the application of it is already a minefield. So won't the simplest solution be to encourage all our youth or young people to enter into civil marriages so that they are automatically then protected?
So my response to that is yes. And that's why I say I don't even know if we should have a codified Islamic law. Because you know what, the beauty about a Muslim marriage is it's not just a sacrament, it's a contract, right? The MJC has issued an ulama, a fatwa, which is simply a legal opinion, it's not binding, saying that incommunity of property is contrary to the Sharia. Why do they say that? They don't have an issue with you pooling your assets and that you have joint ownership. They have an issue with you sharing each other's liabilities, because no soul shall be liable for the debt, for the actions of another. So they're saying you can't be liable for each other's debts. But the beauty about a Muslim contract is it's a contract. It's an agreement. So if you go into that in-community of property default system, but you have to be informed. Of course, that's the proviso. You need to know that this is what it means. I'm happy to share all my property with you, and I'm happy to share my liabilities, and I'm happy to waiver my right to be supported by you. We will have a duty to support each other in this day and age. That's the way it goes anyway. That's the reality. Then why not? And in the best case, if the ulama now really tell the community, no, that's a foul idea, then register your marriage as a civil marriage anyway. Whether it's out of community, without accrual, I encourage people to do it with accrual, because now you don't have the issue of sharing the liabilities, but from the minute you marry, whatever the escalation is, that then subsequently on death to divorce, that gets. So that's this. If you agree to it as an Islamic marriage, because a marriage is a contract, then why not? So absolutely, I tell people, get married. I made my son get married with the ANC. And I encourage all. The only problem, like I was telling Fatima, is the problem is anti-nuptial contracts cost money, right? If you want the ANC, you're going to have to get a lawyer, a notary, etc. But I tell people, you're prepared to pay 20,000 for the dress, 50,000 for the venue, etc., etc. Cough up a 10,000 and pay that notary to do the ANC for you.
Mine was just a comment in response to Fatima Issa with regards to the lived realities. The more we make these things the norm, what is now currently not the norm, make it the norm, have these conversations, that's how we're going to change the lived reality. Where we're giving these religious bodies the authority and we're giving them this acknowledgement, right, which is the current status now. As the next generation, or as us free-thinking women, we must challenge that concept. And the more we do it, the more change we are going to make.
Okay, I think Nomfundo will be the last hand because we need to move to the next, our final session.
Yeah, sorry. Yeah, so I think we're seeing like across like different jurisdictions, very strong sort of conservative movements shrinking sort of women's rights in general across all religions. And what they're doing, and we're seeing in South Africa in the context of the Traditional Courts Bill, for example, is that they're using the law in sort of very smart ways, particularly when you're a minority community, to try to assume more power, particularly to have more control over women and women's lives. And I'm wondering, because at the moment, the status is that there are no Qadi courts, right? And a lot of these authorities don't have legal authority. Are there movements that are happening within Islam in South Africa, where there is, at least from their perspective, a struggle to try to get more legal recognition? Because I think if that is happening from what we're seeing in the context of African customary law, that is or should be the next frontier of the struggle, because they are winning in other jurisdictions of getting legal recognition by using minority rights discourse, and in doing that, being able to assume more power over women's lives. And I'm just wondering, is it happening, and what's going on in relation to trying to stop that from happening, if it is happening?
Happening for over 30 years, trying to get recognition, and there's no political will anymore to see it happen. And I doubt it ever will happen, to be quite honest with you. I don't think it's ever going to happen. I think this new marriage bill, which is going to try and cover everything, is going to probably go ahead. And I don't necessarily know that's a bad thing. Like I answered your question, I don't know if it's a bad thing that, because in Islamic law, you have something called urf or custom, which can also become a source of law. And as a Muslim minority, I think an argument could be made that this is the custom of this country and that we have to abide by it, right? And if the country, and that doesn't necessarily mean that I agree, for instance, with in-community of property, right, as the default system. I think the whole system needs to be re-looked at, not just Muslim marriages, right? And then whatever is decided, if it's a kind of equitable matrimonial system, I don't have an issue with Muslims then slotting into that, as long as both parties and children are receiving the best form of protection during the marriage and on dissolution, which is actually when the problems arise. So yes, there has been so many attempts, like I'm saying, since I worked at the LRC as a junior clerk with the late Soraya Bosch, trying to get up until now, and it hasn't come to anything really, except of course this WLC case, which resulted in the Divorce Amendment Act, which is the first time that there's some form of relief for Muslim women.
There was also the attempt to have a Sharia bench. The Al Jama had put in, I think it was a bill that they put in to have a Sharia bench. So, I mean, that's how serious they are about it. Yeah, that's it. Yes.
They contacted me.
I think they still have it. They
created, and after this Divorce Amendment Act, they created an independent Islamic court. It's just another name for another ulama council with a Sharia court.
Thank you, everybody, for that enriching engagement, and thank you for the presentation. We're just quickly going to play just a quick 5-minute video of it's one of the participants from the community workshop. It really just highlights the lived realities that Muslim women have to go through with religious bodies, as well as trying to use the legal system to enforce their rights. Then immediately after the video has played, can I please have Aisha? Okay, so immediately after that, can we please have Aisha and Fatima back on stage for us to have our last session on inheritance, maintenance, and Islamic personal law to just wrap up the day and any loose ends that we might have had during the day.
Hello everybody, my name is Farika Johar. I was married for 20 years, not counting the years and the months that we were not married, that he left me, because my husband had several, I don't even want to say the word, you know, he was a married man, but he slept around with many women. And for me, that was just, I don't know why. I always kept on asking myself, why? What did I do wrong? Am I not beautiful enough? All these things come to your mind. Because why? Out of this marriage, I had 3 sons, 3 beautiful children, and up till today, I don't know why he decided he was going to have affairs with other women. But yes, in actual fact, that happened to me after many years. he decided to come and just give me the talaq paper. And I was like shocked. But yes, and it was in like the month of Ramadan, which I found very, doesn't this man know his religion? I just found it, and I didn't want to get upset or anything. I just took it and I put it aside because I had to go make food for my children that have to break their fast, who fasted all day. Okay, I left it there. And then when I decided to open the talaq paper, there was no signature on it. There was no witness on it, which must be on a talaq paper. There has to be a stamp of whichever place you went to, whether it was MJC or the mosque we went to, but there was nothing on the paper. And I just left it. And I decided when he's going to come again, I'm just going to hand it back to him. And this is what I was going to tell him. This fraudulent paper that you had somebody made up, typed up for you, take it back to him. And that's exactly what happened. As he came to me again one day in the Ramadan, or after the Ramadan, I can't remember, I gave it back to him and said, this paper, take it back to that person that you had it made by and bring me the original. That's it. So that's what happened. And then I had to wait. And then I couldn't anymore. I went to the court, because then me and my children were starving and I didn't want to ask anybody for money for food. I just felt ashamed. But I had to. I had no other way. I also wasn't working because my husband said, I was working with every child. After every child, then he said, no, you can stay at home. You don't have to work. I'll provide for you. I'm the husband, dad of the house, which must do everything, which he did not do. So I had to go to court. I went for maintenance, but nobody helped me. It was a long procedure. Going early in the morning, having to wait to see an assistant at the court. And then after that procedure, when it's finally your date to come, when you go for maintenance or spousal maintenance, in the interview when you go for the first time, they don't tell you nothing. They just say you have to bring your ID and the children's IDs and have everything ready. But they don't tell you this. You must have all the evidence. You want maintenance for children? Bring the evidence. Whatever you are buying for your children, you must bring all the evidence. So you have no knowledge of that. Then you live destitute, you must come back because you must bring this, you must bring that. You must bring, if you bought the children clothing, you must bring the slips. If you bought food, you must bring the slips. So you just put them off by the court, by the justice system. And then you had to go back and I had to go back and I couldn't anymore. I just got so distraught, I got tired. I didn't have money, I had to go borrow every time for taxi fare, which is humiliating for a woman. And sometimes I had to leave my youngest child with somebody which I did not like, but I had to do it because you have to sit there for hours and hours from 8 o'clock, sometimes till 4 o'clock in the afternoon. And that's the time when I decided to help you because I don't know how they put the papers. But it's difficult for a Muslim woman to go through a talaq and not having the right papers and not receiving it and just expect that it's your talaq. Yes, you must just accept it. I'm talaqing you. I'm finished. I'm done. Because he had a face. He's going to marry this other woman and blah blah, lot of things. But it's not easy. It's difficult. But I had to learn. And I had to struggle, and through this all, I actually became the strong woman which is sitting here today.
Dr. Isop and Aisha.
Thank you everyone for your patience, but we are almost done with this information overload day. So in the last session, we're going to explore inheritance, maintenance, and Islamic personal law in a bit of more detail. You might have touched on these other things, but I think it might be just a bit helpful for people that joined late, as well as for us to just wrap up the day. So the first question I want to engage you guys on as the panel is that how does the principles of Islamic personal law on inheritance and maintenance intersect or conflict with constitutional guarantees of equality, dignity, and best interest of the child? I'll start with Aisha.
Thanks, Kinsani. So, in terms of Islamic inheritance and maintenance, Islamic law, Sharia, it provides fixed shares with regards to male heirs receiving double that of female heirs in terms of inheritance. And in terms of the South African secular law, you would either apply the Intestate Succession Act or the Wills Act when you are dealing with inheritance. So a person can either explicitly leave a Sharia compliant will, and then that estate is wound up in terms of that, or they can have, but the Sharia compliant will have been recognized by the courts as long as it's not contrary to the public policy or constitutional rights. Conflicts in terms of Sharia and secular is where the distribution 2:1, it's in conflict with the constitution, where it says for equality in terms of the constitution. And also then a dilemma that we face is that in terms of the distribution, if a Muslim person writes a will according to Sharia, a disinherited female heir, so a female who's disinherited in terms of the Sharia will, can still challenge the will in terms of the constitution. Did you have anything?
So yeah, to maybe just understand, as I indicated, if you want your estate to distribute it according to Islamic law, you have to indicate that clearly in your will, right? And very few people will say, these are my Islamic law heirs. My wife must get this portion, my son. They don't do that. They simply have a catch-all phrase which says, my estate must be distributed according to Islamic law, and the ulama body, usually the MJC, must determine my heirs on my death. Because in Islamic law, the heirs' rights only vest at the time of the death of the testator, and so that's actually when the heirs get determined. And the ulama body will then issue a certificate indicating who the Sharia heirs are, the Islamic law heirs. Now, the issue is that in Islamic law, a wife, if the deceased had no children, she will get a quarter. If he had children, she's only entitled to an eighth of the estate. So let's say she's lived in that house with him for 30 years, she's only entitled to 1/8 of his entire estate. If he has more than one wife, she has to share that eighth. It becomes 16. If she has more than 2, then that eighth gets split amongst 3. And so now what you find is, I was checking to some lawyers, is that more and more Muslim women are saying that's not sufficient. And what they then do is they put in a claim in terms of the Maintenance of Surviving Spouse Act in order to grant them greater rights on the death of their spouse. The other issue, for instance, with respect to children, as you know, both in the Wills Act, if you stipulate children, it includes all your children, right? It doesn't matter whether they're born in or out of wedlock. It doesn't matter whether they're adopted or not. They're all included. Similarly with the Interstate Succession Act. The thing with Islamic law is a child that's adopted is not regarded as your heir. Can't inherit as an Islamic law heir. So that child, when the ulama body draws up the distribution certificate, they exclude that child. You can leave a bequest up to a third to that child, but that child can't inherit. Similarly, a child born out of wedlock is not entitled to inherit in Islamic law. So what you find when the ulama bodies, when they draw up that distribution certificate, they will ask the surviving spouse, bring us your marriage certificate and bring the IDs of your children. And then they do a little calculation. Because in Islamic law, if a child is born more than 6 months after the couple are married, then the child is considered born within wedlock. If the child was born less than 6 months and it's not a prem child, then that child is considered born out of wedlock. And that child too will not inherit as a child in Islamic law. So there you're looking at, can you imagine the kind of factual issues at play here? And can you imagine the later siblings will obviously raise it, but my Buddha was you know, they will raise it, but Buddha was not part, he wasn't conceived. And then they'll do the calculations and they'll challenge that particular child's right to inherit. So there's a clear, aside from the obvious 2:1, there are other issues as well that will potentially not meet constitutional scrutiny if it was challenged.
No, please keep the microphone. I just want to just ask a further question on that to say that, so does the religious body do this distribution and liquidation themselves?
Yes.
So you don't necessarily have to go to the master's
No.
to the masters.
No. So what happens is the will say, most of the time they will say the ulama body must determine, and in Cape Town, the Muslim Judicial Council is the main body that draws up. So they have a special estates department at the MJC, and that imam just churns out distribution certificates. Lawyers in Cape Town all send their file, and then they draw up that distribution certificate, which stipulates who the heirs of the testator are.
So it's different to the L&D. So they don't do the liquidation and distribution. They don't do the L&D. They just stipulate who your heirs are, your next of kin, and in what percentage those heirs inherit.
You have to still do the next of kin affidavit, and hopefully in that next of kin affidavit you include all your kids, right? And then, but then you also have to bring your marriage certificate, that little pink slippy that I said you get from your imam. And you have to obviously bring your kids' IDs or birth certificate, and they'll do that calculation. And if the child was born, if somebody had a child before he got married and that child was born out of wedlock, then irrespective, there's no calculation done. That child just doesn't inherit.
Even though they're a minor?
Even if they're minor, they don't inherit. And so in Islamic law, you only have what you call freedom of testation over 1/3 of your estate. So you can actually leave to your adopted child, to your child born out of wedlock, you can leave 1/3 of your estate, right? So that's what a lot of people do. They leave 1/3 of their estate to their adopted kids or to their children born out of wedlock. Heir, who's not a lawful heir. And because they don't qualify as lawful heirs, similarly in Islamic law, non-Muslim relatives don't qualify as Islamic law heirs, right? So if your wife is a non-Muslim or your husband is a non-Muslim, they're automatically excluded as an Islamic law heir. But what you can do is you can leave up to 1/3 bequest to that spouse if it's a non-Muslim spouse.
And also within your lifetime, you can do with your assets as you please. So that will still be.
Yeah, but I think what I'm getting is that, but that approach, when we're looking at it from a constitution perspective, it actually perpetuates gender discrimination.
Yeah, but there's freedom of testation and freedom of religion. So which is why if you choose to have a Sharia compliant will, then you must be aware that these are consequences thereof. And then understand that up to 1/3 of your estate you can bequeath to anybody. But the other 2/3 would go to the lawful heirs.
Can the heirs actually challenge this in the courts? Can you challenge?
Yes, they can. And it hasn't happened before because they generally sort it out amongst themselves. And you have many times when there's dispute that either the lawyer or the ulama council will mediate those disputes. They absolutely can, but that hasn't happened. And the question is, if it does happen, if it is challenged, will it actually pass constitutional muster? Because as we know, in B, the court overruled primogeniture And similarly, we have the Diaga case, where the court went into a private testament and over kind of struck out provisions that were discriminatory against the female heirs. So it remains to be seen what the courts will do if that ever had to come before the court.
Just you can keep the mic, Dr. Esop. I just want to find out, so would you then say from that that can the South African legal system accommodate plural systems in this regard? Do you think that it has the capacity?
That's a super difficult question. I find it that, because if you look at African customary law, right, the ideal is to have plural systems. But what has happened in African customary law is that if you get married now, it's automatically in community, which is the common law. What has happened to succession? If you die interstate, the common law kicks in, right? I'm not saying that primogeniture should have been upheld, but the fact is the default position appears to be the common law. So in which way are we actually accommodating plural systems? And it's a very relevant question. I don't necessarily have the answer. Is it possible to have plural systems? I don't know. Maybe others in the audience can speak to that, because it's really difficult. And even if we did have it, how does one enforce it? And how does one ensure that every system is compliant with the Constitution? Right? Because African customary law was deemed to be unconstitutional and invalid, the rule of primogeniture. Similarly, if this had to be challenged, I don't know if it will be, because the court has this adherence to the doctrine of entanglement. So it's not sure whether the court will intervene in the same way like it did in B.
I just say one thing with regards to the males receiving double of a female, right? 2:1. There's a reason behind it, where they are meant to take care of the female family members. But that's not the lived reality. Right? That's not the lived reality, where a brother who's inheriting double is going to take care of his sister. And therein lies the problem.
So it's
I don't have a
essentially-
solution.
So it's essentially what we actually see, what we saw in Bay initially. So it's literally the same thing. Okay. And then what role do you think the judiciary can play in balancing respect for religious freedom with enforcement of constitutional rights when we're talking about inheritance and maintenance?
So maintenance is something separate, and this is something that I always have to explain to people, is that in Islamic law, the father is responsible for the nafaka, or the maintenance of the minor children, right, till they become self-sustaining. But I always have to explain to people that, especially upon divorce, both parties are liable. Right? And that's not necessarily inconsistent with Islamic law to say that if the mother's working, she should too be liable to support her child. And this is something that either way, even though that's the case in Islamic law, I always explain to parties that South African law is what the law that prevails. And in terms of the Children's Act, the best interest of the child will always prevail. And so, for instance, many times, some of you might work in this area, the woman will say, he's told me that if I leave him, he's going to take the kids from me. Because in Islamic law, if I remarry, then he gets custody of the children. Then I always have to explain to them, look, first of all, Islamic law doesn't apply in this country. Secondly, nobody uses the term custody anymore. Thirdly, you can't take the children from you because the best interest of the child prevails, and the court is the upper guardian of the child, and the court allows both parents contact and care of that child because they use that against women. So it's in certain instances, it's very difficult because our courts have tried to uphold certain aspects of Islamic law, for instance, in divorce and marriage. But I know there have been a few cases where the courts have spoken out strongly against the practice of talaq. I think it was the Owen Rogers judgment where he said it's completely unacceptable that a man can just say, I talaq you. So obviously, in those cases, especially where it results in injustice and like this poor woman who just was on the screen now, then I'd say seek your rights in the South African system, where at least you know you're going to get a better, a more just outcome.
But also, the court doesn't create the religious law, but it needs to apply it in terms of constitutional principles. And that's where the judiciary comes in into play there. They need to look at how, if justice and fairness and kindness, and making sure that no one party is unduly disadvantaged. And even when we look at in terms of Islamic law, where the father is, the children go to the father, but in practice it's not, it's the mother. So I find in practice there's selective application of Islamic law and Islamic principles as opposed to justice and ending a marriage on a footing that's just and kind and fair and equitable.
So what has happened in our courts is that the courts have used this doctrine of entanglement to avoid dealing with religious issues. They will say, oh gosh, no, this is religious, we don't want to get involved, so they step back. And this is problematic because sometimes it's not even an issue of doctrine, it's an issue of dispute of fact. He says, I did talak you because he wants to not have any responsibility. She says, but you didn't talak me, I'm still married, you're still responsible. And then the court says, oh, we can't get involved here, this is doctrine, and we're going to uphold it, and South African courts uphold the doctrine. And I think that's just an easy way out, right, to avoid trying to deal with the actual issues. And I think that's quite problematic on the part of the court side.
Yeah, no, thank you for that. I think definitely maybe that's also why we had the Muslim marriage bill abandoned after 2010, because no one has the political will, and also nobody wants to really rock the boat per se.
But even that, there was huge kind of opposition to the Termination of Pregnancy Act, or even the Civil Unions Act, right? From the religious bodies, there was huge opposition, but it went through, right? So is that a good enough reason to have not pushed? Unless you're saying that the lobby against it was so strong and so connected that it would just never see the light of day.
I actually lost my train of thought. No, it's okay. And I think just to round up our conversation from this morning to into this afternoon, what would you say that are the reforms or how we should interpret approaches which could ensure that Muslim women do not fall through the cracks when we're doing this work, be it divorce, be it inheritance, be it maintenance, what would you say is something that we as a collective can collaborate on, just to ensure that women don't fall through the cracks and that they just don't give up, right? Because that is the thing, like women are so frustrated that they've been going for help and no one is listening, and as a result, they just give up and then start from scratch when that is actually not necessary.
So, I'm this is my concluding remarks in terms of the Muslim Family Law Hub and the three doors, for instance, the door of marriage, the door of divorce, and the door of inheritance. And like Aisha said, at the start of the marriage, women need to be educated about what they can include in their marriage contract. So that's the first step. Women need to be educated. Secondly, we need to make it as an accessible, especially financially, for couples to actually conclude antenuptial contracts in terms of South African civil law and thereby protecting themselves. So that's very important, is that when you enter the marriage, you make sure that you include provisions that will protect you in the event of divorce. What's very interesting for me is that even educated and professional women, even if you tell them this, it's not necessarily something they pursue, which is so frustrating. So the idea is to change the narrative on the ground and to change mindsets, that it's acceptable to ask for certain things in a marriage contract, and that you go through, you see it through till the end. At the point of divorce, I think for me, at the stage we find ourselves in now, it's getting attorneys to assist women who are going through the Islamic divorce to access the Divorce Amendment Act and to issue summons and to go through the process of Rule 43s, because there are many women who can benefit from that, but they don't have the legal resources to do that. They, especially those stay-at-home moms who gave up their years of life, and the husband is, and there are so many cases where the husband's so wealthy and she can't get anything out of it because she doesn't have legal representation. And at the end, in the case of divorce, I think it's very important for women to have these discussions with their spouses, especially. You know that I'm only going to get an eighth when you die. Can you make sure that you in your lifetime, donations between spouses doesn't attract tax? So make sure that in your lifetime, you have your husband donating property to you, creating this is especially for women who are not employed. For women who are employed, I'm always telling women, make sure you're financially independent. Don't be dependent on a man. But in the case that you did give up your work and then make sure that you have those conversations and that you are ensuring you're not waiting for that Islamic will, that in your lifetime you're securing yourself assets from your husband.
Absolutely. Mutual consultation. I still maintain at before you even focus on your wedding dress and your decor and your caterers and your venue, have that one-on-one consultations with an attorney who can guide you, to reach an agreement that you are both comfortable with, and knows what some of the concepts are that can be included in a Muslim marriage contract. Also, cost-wise, it's always a deterring factor when a woman needs to litigate. So, ensuring that you are, in your life, I'll speak from experience. I was married for 19 years and I always felt that I was financially secure, right? But upon divorce, I wasn't. I realized that it's not financial freedom that I had, it was financial dependency. And that's what we need to understand the difference between the two and ensure that we as women protect ourselves. So that marriage contract, which will stipulate everything about your marriage, how the marital regime, who's responsible for what, even a woman who contributes to the home, that can be a debt on the husband. All of those things must be considered. And we need to keep the conversation going. We need to have more of these campaigns so that we can reach the furthest community where it's actually this education and empowerment is needed so that they don't have the financial means to come here to town maybe. So we need to go to them and we need to keep this conversation going. That's the only way we're going to empower and uplift our women so that we end the cycle, because it is a cycle of abuse.
I don't know if anyone would like to ask final questions, final thoughts. Is there anything online?
Yes, I do have a question.
Oh, online. Oh, okay. Yes, you may proceed.
Assalamu alaikum. Good afternoon, advocate and everybody else in the room. I have a question regarding inheritance under Islamic law. If my husband is Muslim, but his parents are Christian, would I have any claim to his estate under Sharia after he passes away?
Under Islamic law, if they're non-Muslim, they're not automatically heirs at all. So if he has to have that standard provision, the MJC won't include them as an heir, but he can leave a bequest of up to a third to his parents, if he so chooses.
Okay, thank you so much for that. And I just have one more question. I'm married for 13 years now at the MJC only. So can I still pull up a contract after all these years?
Marriage contract, yes, you can. I think it's important that you do, just to protect yourself. It's very difficult to get somebody who you've been married to for 13 years at the table to agree to certain terms. But inshallah, I wish you all the best and hope that you can reach some common ground on and a way that's going to be equitable and fair and not leave you disadvantaged.
Okay, thank you so much.
At the best time to have, the time when you have the best bargaining power is when he's still in love, mad in love with you. Because love makes you laugh. I always say love makes you laugh. So then you can persuade him on just about anything. But once you've clinched the deal, it becomes harder, right? So even if you can't get him to the notary to sign an anti-nuptial contract, what I would strongly advise you to do at the very least is when he's in a good mood one night, to say, don't you want to at least transfer half the property into my name? Then we both share equal, because I find that that is one of the biggest issues on divorce is a woman doesn't have security of tenure. She has nowhere to go. She has nowhere to live. And even if you get him to sign half the property into your name, then you've got much more than many women do. in Muslim marriages, that is. So even maybe asking him to go and sign the anti-nuptial might be a bit of a stretch, but what you can do is persuade him to put the half the house in your name. And if you really, really push it, can't you put that car also in my name? And then you can always say, don't you want to put something away every month in a investment account for me? That kind of thing, but you build on it a bit by bit. And very importantly is, and a lot of Muslim women don't have this, is you must have your own bank account. Even if you're not earning, you start having your own bank account, and that money that he gives you, you start saving for your own financial future.
Oh, thank you so much. That makes sense.
Is there anyone else online before they can just unmute and speak? Okay. If there's no one else, we can take questions in the house.
Hi there, Katura Adrianza. I just have a question that largely we're dealing with marriage in general on the basis of the patriarchy, where the man's house, head of the household, is provided for the woman, and very little agency and all of that. Now, in the situation where Islam allows women to have, if I'm saying it correctly, is it the mahar? Is it correct? Okay. So why would it then be customary for them not to use that to actually gain security? Because you could gain security in the marriage as well as possibly defer some of it for security for your inheritance. So why is it not encouraged by, let's say, older women to tell younger women, please make sure that you actually get sufficient funds or some sort of security at the beginning so that you don't face these situations that we are facing and dealing with?
So before you get married, you're very much in love. And then all you ask for is spur money. 500 Rand. I call it spur money. You go to spur once and you'll spend more than 500 Rand. But that's what in practice people are asking for 50 Rand or 100 Rand or 5 silver coins or 5 1 Rand coins. That's the kind of mahar that people are asking for. And it's not invested. So there are other mechanisms, even the fact of like deferred mahar, that wasn't something that I knew about when I got married. Practice is the parents will ask, my daughter wants X, Y, Z for mahar. But so that's why these type of education drives are important, where we can teach them that you can ask for the deferred mahar. Maybe the guy can't afford something now, but it will be a debt on him. So upon death or divorce, if he hasn't settled that, if he hasn't paid you your mahar, it's a debt on him or on his estate. So that's why it's important. Don't ask for spur money, and think about a deferred mahar, where you ask for something tangible. You can maybe do a monthly investment for you, 100 Rand a month or 200 Rand a month, spur money every month, but it's in your name.
I just say that in classical Islamic fiqh, there's no maximum. You can ask whatever you want. And in fact, in certain countries in the Middle East, it's very difficult for men to actually conclude the marriage contract because the women are asking so much. And what I find is that, and Aisha's correct, you can ask for an amount up front. So he's a medical intern now, so maybe he's not earning that much, but you know that in 10 years' time, he's going to be creaming it. So you want to make sure that you ask for the deferred mahar that then becomes payable either on death or divorce or at a stipulated time. But what I find is that women are not necessary, and so we have education. We had a special workshop, the Hub, on anti-nuptial contracts, where we educate women about this, that your mahar can be a form of security. There is no maximum. You can ask upfront, and then you can ask deferred. But I find that sometimes women they're too shy to ask this. Now, in Islamic law, actually what happens is, remember we told you there's the nikah, but actually generally in South Africa and in Cape Town, the father acts as the wakil or the prince on behalf, the guardian, on behalf of his daughter when the marriage contract, the offer, he does the husband does the offer and the father does the acceptance on behalf of the bride. And so what I tell women is, if you're uncomfortable asking for a house registered in your name, then get your wakil, your guardian, to do it. That's his job. It's not just to sit there in the nikah and say, I accept on your behalf. It's for him to negotiate the best deal for you. because he's looking after your interests, right? Whether the wakil is something in South Africa. So make your wakil work for you. If you're too shy to ask that guy because you're so in love, get your father to negotiate with his parents and with him so that you get the best financial outcome for yourself.
Hi, two questions. One, you had spoken about you said that in a Muslim marriage, if the children, then the wife gets a 1/8, and you said if there aren't any children, the wife gets a quarter. I just want to know what happens to the 3/4. And number two, what is happening to the education to the boy child? I hear like we're educating the girls, but why aren't we educating the boys to tell them to not grow up to be pieces of nonsense like the current men? Like I just don't understand, because they are the ones who grow up to perpetuate this practice, but why aren't we educating them as well?
I just have a few comments to make. One is that I think it's about education. My experience, including myself when I got married, is that I think there's still an extreme reluctance to ask for things up front. And I think, and I know for a fact from people that I know, they would say, oh, um, there's a lot of demands, they want a lot of things. So, when the culture, and I think one mustn't forget the culture, and the culture has always been, even with my own parents, that everything is ours. It's a unity, it's a unit, and you don't go into a marriage without a unit. You're always that. And I think a lot of us, it's actually quite difficult to understand. I also just want to make one comment. I also had a client, by the way, that was married in Hindu rites. I know that she went all the way to court, but she went on the basis of declaration that she is married, and asked the court for a divorce. But that didn't really get proper ventilation. But that's just something else aside.
Yeah, the amendment, the Divorce Amendment Act, it only reads in Muslim marriages, so it's not extended to other religions. So that is the problem there. So it's also still unconstitutional if you look at it, right? And then the lady in the back there, yes, our sons must be educated. I have 3 sons, and they go with me to workshops, and they know exactly, what's going for what. But it is important for us to educate our sons and our daughters equally. There was something else that you had about the other 3/4. Yeah.
So Islamic inheritance law is one of the most complicated systems of law. But to just answer your question, a husband, if the wife has no children, will get a half. If she has children, he will get a quarter. A wife, if the husband has no children, will get a quarter. And if he has children, she will get an eighth. If he has more than one wife, the eighth gets shared amongst the 4 of them, or 2, or 3, or whatever. You will never get more than that as a spouse, right? You will never get more than that. So then if he's survived by a wife and a son and a daughter, the wife will get an eighth, and the residue will be shared between the son and daughter, 2:1. That's an easy, simple scenario. If he survived by a wife, a daughter, and a brother, an agnatic brother, in other words, they share the same mother and father, then the wife will get 1/8. The daughter will get a half, because it's very explicit provisions in the Quran, which is the primary source of Islamic law. She will get a half, and the balance will go to the deceased brother. Now, when people put Islamic law in their will as that generic clause, they don't understand that on their death, this is what's going to happen. And in fact, that estranged brother of their husband, who they haven't seen in donkey's years, now suddenly has a share in their house. People don't understand that when they put that generic provision, right? There are many aspects of Islamic law that people don't understand how it's applied. And so it can be quite problematic if you have that generic provision, because suddenly you have family members who are owning your house that you would never have thought have ownership to your, what's the name?
Follow up, maybe I was also looking for the most simplistic answer. Say, for example, it's just myself, my husband, and he dies. Do I inherit everything, or do I inherit this half share or a quarter?
So this is also very interesting. In Islamic law, there's something called rad, or surplus, right? If there's a surplus, you have Quranic share heirs, of which a spouse is one. So if there's no kids, and the two of you, it was only the two of you, no father, no brothers, only you. Is that your scenario? Or he has a father and he has brothers?
No, I just need a full-term course.
It's very complicated. So if it's just you, then
Let's just say it's just me.
It's just you. Then Islamic law, you are entitled to 1/4, right? And then there's a surplus of 3/4. Now, there's differences of opinion according to the schools. Like the one school says that they don't believe in this notion of surplus. The other school says that a spouse is never entitled to the surplus. Right? And in fact, the one school, the Maliki, says it goes to the public treasury. So they will rather give it to the public treasury than giving it. So what happens? So in certain countries in the world, they have now ruled, I think it's in Tunisia, I think it's in Pakistan, I stand under correction, but in certain Muslim, I'm not sure if it's Malaysia, in certain Muslim countries, they have now ruled that if there's no other relatives, in other words, no other relatives, then the spouse will be entitled to the surplus. In other words, the rad. But it applies both ways, male or female. It's called, so if there's a surplus and there's a father, let's say he's survived by his father and his wife will get the quarter and the father will take the rest because he's regarded as an agnetic heir.
But he wasn't sleeping with his father, Aibo. And also just...
So in Islamic law, the agnetic line is very strong. And this is also problematic in terms of constitutionally, not the female line.
Just to follow up on the 1/8 share, you said the 1/8 share is shared amongst the polygamous wives. When you say, are you saying that, I mean, obviously the fractions will be different if the numbers are different across, but you mean that the 1/8 share is shared between the 4 spouses?
Yes.
So not 1/8, 1/8, but
no,
all
it's
1/8
divided by 4.
Why it would be better for her husband not to have a will? Because then she gets a child.
Then she gets it, yeah, or 250,000. Yeah. It's a lot, eh? It's a lot to comprehend. But yeah.
Oh, it's a lot.
So if there's a wife and then the husband's father is still alive, he gets the remainder, the 3/4 of the estate. But the responsibility is on that father-in-law to take care of the wife, am I right?
So this is the issue when you speak about educating the men folk. And a lot of the time, to my frustration, it's only women who attend these workshops, right? And when in fact, it should be both. Right? Unfortunately, one of our workshops, and the anti-nuptial one, we had lots of men there as well. But and that's very important, is that men are educated. And when we had an inheritance workshop, but it was in Women's Month, so it was only women. The reason behind the husband, it's the same like in primogeniture, right? But maybe not, also maybe it's not exactly the same. Because in Islamic law, the son or the man is responsible, for instance, for paying a mahar, which becomes the woman's sole property. In Islamic law, the husband is solely responsible for maintenance, not the woman. If she earns, whatever she earns is her property. She can do with it as she pleases. In Islamic law, that son is responsible for his mother as well. And that's why the argument, and he's responsible for the children, and he's responsible for his sisters if they're not working and they don't have husbands. So the argument goes that he is responsible for more financially, and that's why he gets double the share. But that's the lived reality doesn't always match up to that.
Correct.
Is
Then
that
they
they
just
not
forget
many
about the
times they
widow.
don't necessarily fulfill, not always. There are obviously cases where men do fulfill the responsibilities to all those female members in their family, but not always the case. And so you're right. It needs an education. You're getting twice the share of the woman because you have more responsibility. So don't shirk it when you get that double share.
So, and the wife doesn't have to take care of the children with her share. Oh, yeah. The other question I had is that if you have a couple with children and if the husband in his will leaves everything to his wife, and then upon her death, then it gets split according to Sharia. Is that in line with Sharia law? Is that
That's not a Sharia compliant. That's
not?
not the Sharia will, because your Sharia will would say it goes to my Sharia is at the time of my death. So
Okay.
if he's saying in this will it goes to his wife, they already it's not Sharia compliant.
Okay.
And you can't rule from the grave.
Yeah.
Can't rule from the grave.
And then the last question I have is around maintenance. In a marriage, so a husband obviously has to maintain, he has the obligation to maintain his wife. But like the example you had earlier, where the husband is a medical intern, for example, and he's not earning much right now, and the wife is assisting him, at some point, if she does not waive her right to receive it back, as he has to eventually pay it back in.
But that's why it needs to be reduced to writing. It's important that you have it in your contract because you can't, upon divorce, say, you know, I was doing this that time, but you hadn't had an agreement that it would be a debt on him.
If there's a lack of.
But hold on, if you're in Cape Town, you still have Rylands versus Idros, which you can
Yes.
rely on, which allows you. In that case, there was no written contract, but the court recognized that one of the consequences of a Muslim marriage is that a husband has to nafaka the wife, and if he didn't and she did it, that she could claim arrears maintenance for the years that she did support the family. Instead, the court recognized it without a contract. But the only problem is in Islamic law, she could claim for all the years that she supported for the family. But in that case, the court said, I think it was Fagan, he said no, because of the Prescription Act, she can only claim for the last 3 years. But that's a high court judgment, not a Concord judgment. So if you, that's why I'm saying, if the Western Cape, you can rely on that, arrears that judgment.
Okay.
So maybe just a comment because, you know, as much as it's very overwhelming to hear or, you know, about the Sharia shares in terms of inheritance. And I also used to have that approach of, oh my goodness, this is unfair. And I've learned not to question it because it's obviously Quranic injunctions. But I just wanted to mention that there is also, so we need to educate people as well, because when it comes to fairness, we must also remember there's something called a redistribution agreement as well. So if the estranged uncle is now inheriting, it's up to that estranged uncle to be able to come to his nieces and nephews and say, you know what, I was never part of this family, whatever, I'm prepared to waive my inheritance and the rest of the family members can also inherit. So I just wanted to say, notwithstanding the shares, there can also be a redistribution agreement entered into. Thank you.
But also just bear in mind, there's certain, you know, when you're waiving, what's the term? I can't get to it. First up is, you know, so he may renounce or revoke, but then what about going downwards?
You know, there's many Muslim estates that have not been wound up for years, precisely because of this issue. So it's wonderful. Of course, you can enter into the distribution agreement, but why would the uncle give up his share in that house? Right? Like, I mean, really. So that one, so there's, yeah, right. So there are many cases where that file has been lying at the master's office for years and also the other problem is, can you imagine all that fractional shareholding in that house, right? So let's say that in many cases, the house is the only property And so now the father leaves, he thinks he's doing everyone a favor, and he says, according to Islamic Sharia, my whole estate, but it's only the house. And so he has a wife and a brother and two daughters. And so it's a eighth, 2/3, and the brother gets the residue. But now, wie gaan die betale rates, and who's going to play the water, and who's going to live there? And for years it goes on because they can't decide they're going to sell it. No, that's not good enough, and blah, blah, blah. Very complicated, and people don't necessarily realize how problematic it is. Best case scenario is all the heirs with a fraction agree and they sell it and everyone gets their share, but that's not always the case. Yes, I'm sure. Because can you imagine you have like a 3/53 share in a house? It's like crazy. See that?
Yeah, I think mine is exactly to speak against all of this, right? Because what's happening is you've got a system of distribution which most people don't know about, but we're insisting must be applied. And what we know in lived experience produces gross injustice. So we actually, I think education is important. I'm an educator myself, but I think more valuable than education is advocating for change. The whole system has to be changed. Where a system of Islamic law, of Islamic inheritance is producing injustice, we can no longer call it an Islamic system. It might be a Quranic system, and the degree to which we have to challenge it is the degree to which it's producing injustice in society. So mine is a different appeal. I think education is important, but that's not where I think we need to sit. I think we need to sit in organizing so that these systems are changed, so that you have a different system of distribution, so that you can actually, and there's mechanisms with the Islamic law, believe me, the kind of acrobats we do around usury and interest, we could do half those acrobats around this and produce justice. So a completely different appeal to change the whole system rather than to sit within it.
Okay, thank you so much, everyone. Thank you, Prof. Sidat. Thank you, Dr. Esop. Thank you, Aisha. Thank you to Bowman's for sponsoring our event, the venue and the catering. And just thank you to the WLC team, and thank you to everyone that has taken the time of their busy schedule to spend this day engaging us and for us to all grow together and collaborate in what actually happens with advancement of women's rights. So that's the end of it. We didn't get a chance to get into the network. However, if you would like us to add your law firm on our pamphlet for women in Muslim marriages, please drop us an email with the details, because as Charlene said, we can't attend to all the cases, and those that we can actually attend to, if we can't, we'll just give the women the contact details. I know there are some law firms that offer like a reduced rate, right, for women that are unemployed. So please just send us your details so that we can just include everything in our pamphlet so that we know where to refer women and for which issues we should refer them to. So thank you so much. I hope you guys drive home safe. And I hope that when we have our conversation on the marriage bill or the marriage act in the next year or so, that we'll all come together and collaborate again. Thank you all.